John has a conflict on the first case.
That's correct.
Okay.
And we should be live.
And Emma's only on the phone right now, correct?
Yep, Emma's on the phone.
Okay. I think we can probably do the recommendation agenda items with her on the phone. So let's do that. All right, let's go ahead. Maybe Douglas will join, but let's go ahead.
And Doug just texted me and said that he is trying to join, but it's saying it won't allow him to enter the meeting room.
Okay.
Let me, here, I'll send him the link again.
I saw that Teree joined. And I also saw that Thomas joined. Welcome back, Thomas.
Thank you. Glad to be back.
Is it a short term or do we know yet?
It should be a very extremely short term.
Okay. I don't know what that means, but
it should, at least from what I understand, maybe by your next meeting or the meeting thereafter, we'll probably be transitioning further in the office with a permanent replacement.
Okay. Max, we ready to start?
Yes.
Okay. Good morning. The September 29th, 2020 meeting of the Charlotte Zoning Board of Adjustments is now in session. I am Rick Sanderson, chairperson. Also sitting on today's board is Terry Brown, the vice chair, Deborah Dryden, Welch, Emma Allen, Douglas Wilson, and John Floyd. Also present are Chef Spencer, the zoning administrator, Lisa McCarter, the planning project manager, Teree Hagler-Gray, senior assistant city attorney, Thomas Power, senior assistant city attorney, Max Oliver, clerk to the court, David Good, Charlotte Mecklenburg Stormwater Services, Karen Weatherly, senior assistant city attorney, Atkins Court reporting, verbatim reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the third remote meeting of the Charlotte Zoning Board of Adjustment. And I would like to ask for your patience today as we proceed. There may be some slight delays as we transition between speakers and participants and presentations. The Zoning Board of Adjustments is a quasi-judicial body that is governed by the North Carolina Journal of Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with newly enacted state statutes passed the North Carolina General Assembly in Session Law 2020-3 that allows for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed. This meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicants and the public in a number of ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property, and we notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contained information about means public can access today for meetings. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This was also included on the board's website. Today, one type of case, application for a variance from the regulations of the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony pro or con must be sworn in. The zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for their case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak, pro or con, will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, September 28th, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting as a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk, and the documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with North Carolina General Statute 160A-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will hear 6 cases today, 4 recommendation agenda items, and 2 regular agenda items. The first case is case number 2020-063 for 3007 Blue Heron Creek Road, presented by Lisa McCarter. Clerk to the board will read the names of anyone who opposes a case. So, did Douglas join us? Yes. Okay. So for this case, Douglas, will you participate as one of the 5 board members hearing the case, since we have 4 board members and 3 alternate board members attending. Douglas and John has a conflict. Douglas, would you sit in on this case
Yes, I will.
since
This
you
is
have to leave early?
for 202063, correct?
Yes. All right. So for is this going to be Lisa and Shad on this case, or
David Good is presenting, and we're trying to figure out the technology right now. Just give us 1 minute.
I need to get you and David and Shad sworn in? So
Okay.
you want to go ahead and do that?
Yes.
Do you swear to tell nothing but the truth in the matter at hand? Lisa?
I do. I do.
David? Shad? Okay. Shad? You're muted, but okay. You're nodding your head.
I do.
And David, okay. Thank you. So this is case number 2020-063.
Good morning. I'm David Good. I am the Floodplain Administrator for the City of Charlotte, and I'll be presenting the staff's case. This is a variance from the floodplain ordinance to construct 2 multifamily buildings and a maintenance building using the elevations on the adopted floodplain maps at the time the subdivision plans were approved, rather than the higher elevations on the preliminary floodplain maps that were in place at the time. The property is located off of Mallard Creek Road, near the intersection with W.T. Harris, and it's directly next door to the school. The property is zoned multifamily conditional, and the buildings out there at the moment they're already constructed are multifamily buildings. This is a aerial view of the site when it was graded and cleared. Currently, you'll see in the next several slides that the buildings are actually already in place. This is another close-up view. Oh, this is the view, the current view, aerial photo of the site as it is today. And this view shows you the floodplain maps, the current flood version of the floodplain maps, and the arrows point to the 3 buildings that are the subject of the variance. 2 are multifamily residential, and the other building's a maintenance building. So this is the current, what we call effective floodplain map. This slide shows the floodplain map that was in effect when the subdivision plans were approved back in 2018. And I'll get into the details of the chronology of why that's important. But this was the map that was effective. And you have to have a floodplain development permit for any building that touches the community floodplain, which is that sort of dark gold or dark brown or brown line that's touching 4 buildings on this property. It's hard to see. But there's 4 buildings that touch the floodplain. They're what we call habitable buildings that would have to have a floodplain development permit and comply with certain construction elevations or lower elevations. One of the buildings, the building on Verdant Hill, isn't the subject of a variance because it was built compliant with the current floodplain map. This is a picture of what it looks like today. These buildings look like today. As I said, they're already, 2 of them are complete and 1 building is close to being complete. That's the subject of variance. What they're requesting is a variance from a provision in the floodplain ordinance that requires the floodplain administrator to use if there are two sets of maps. And so what happened in this case is we had the effective maps that were adopted by FEMA, and at the same time we had preliminary maps, which is basically we were updating the floodplain maps, and they were preliminary, which means that FEMA has approved the maps for distribution to the community for a comment period. So the community has a long period of legal, and this is all set out in the Code of Federal Regulations, in which the community can review the maps and make comments. And during this period, and I'll go through the chronology, we had two sets of maps. We had the effective maps, which we used to regulate, and a set of preliminary maps that would become the adopted maps after the subdivision was adopted. So the chronology is such that we had the effective maps that we used, but we had preliminary maps were issued in August of 2016. The applicant for this subdivision, multifamily subdivision, applied for multifamily subdivision review in March of 2018. Then they requested a floodplain development permit in June of 2018. The multifamily plans were approved in August of 2018, and in November, what were preliminary maps at the time became the effective maps that we use today. So when we have two sets of maps, what the ordinance requires is that we compare the two maps and use the higher elevations, whichever is higher, effective or preliminary, we use those maps. This is what FEMA refers to as a higher standard. The City of Charlotte has a higher standard than the FEMA or National Flood Insurance Program minimum standard. So this is a higher standard. And at the time the subdivision plans were permitted, they were permitted using all the elevations on the effective maps at the time, and they were compliant at the time using those maps. So the applicant went forward and constructed the buildings according to the approved plans. And what happened is when all the buildings were complete or close to complete, the applicant had to submit elevation certificates showing all the elevations for the building. And it was discovered that they have built the buildings compliant with the approved plans, but they hadn't built the buildings using this higher standard. And so that's the subject of the variance. All of the buildings out there, said two sets of standards. There's the minimum FEMA or National Flood Insurance standards, and then there's a higher standard that the City of Charlotte applies. All the buildings out there are compliant with the minimum FEMA NFIP standard. So staff has requested, and it's my understanding that the applicant has agreed to a certain set of conditions in order to protect the residents and the property of the people living in these multifamily buildings based on Charlotte's higher standard. So essentially, we are trying to limit the risk and make this building and the people on the property reduce the flood risk, reduce their impacts from a flooding event with a set of conditions. And the conditions are they have to maintain flood insurance on all three buildings. They have to notify tenants in the lowest floors that they may be subject to a higher risk of flooding and recommend flood insurance for contents, which they have to install a flood warning system and a cabling system and flood warning signs in the parking lots that are below this higher level, so that they can warn folks to move their cars and so that the cars will not migrate off the site if there is a flood. We're requesting that they confirm that all electrical and mechanical equipment is elevated above the flood protection elevation on the original plans. We also wanted to make sure that it was understood that this variance this is not a variance from these, what we call a substantial damage, substantial improvement revisions of the ordinance. They've agreed to, or they have agreed by this condition to forego any kind of local funding from flood mitigation assistance in the future. And they have to maintain a path to these buildings at the level that they have today. And that's the conclusion of my presentation for this case. I'm open to any questions.
Okay, thank you. Is there anybody that wishes to speak in opposition to this variance? Max, is there anybody?
No one has signed up to speak in opposition to this case.
Okay. Does the board have any questions?
This is Terry Brown. I have one. Is there a particular reason? Is there something particular to this area of why Charlotte has a higher standard than the FEMA standard, or is it just blanket across the entire city?
It's blanket across the entire city. The city has adopted this higher standard the purpose of this higher standard is to prevent, what we're trying to do is require that property owners elevate their buildings to a higher elevation, because over time in Charlotte, due to development and more impervious area, those elevations tend to creep up as we remap any areas all over Charlotte. So it's not particular to this area. It's all across the city.
Okay, thank you.
Any other questions for staff?
Mr. Good, what does it mean if we deny this? Does he have to tear the buildings down? What's the alternative if we don't approve this rezoning?
If you were to, he has several options. The applicant would have to, one option is to demo the buildings. The other option is to elevate the buildings, which means he would have to lift these buildings up above the current flood protection elevation, or he could abandon the lower floors on these buildings and install vents, or what we call wet flood proofing, that would allow the water to enter and exit the building. So there are options, but obviously they're expensive. Correct.
Okay, but he did build these buildings in good faith because he thought he had the correct permits, correct?
Yes. Yes.
Okay.
The plans were what we call compliant with the effective floodplain maps at the time.
Okay, thank you very much.
Yeah.
Mr. Good, what's the difference between the elevations, the actual difference measurement wise between where they were constructed versus where the higher standard is, roughly?
Roughly a foot or a foot. Yeah, maybe in some cases 1.5 feet.
Okay, thank you.
Yeah.
Are there any other questions for staff? Was there a motion? Max, get a motion. Max, did you send out the findings of fact and conclusions of law?
I will do that now. I have the emails drafted. Sorry. I'll be more prompt next case.
Okay, is there a motion?
This is Douglas Wilson. I move to approve the variance.
Thank you,
This is
Douglas.
Terry Brown. Terry Brown, I second that.
So we have a motion by Mr. Wilson, a second by Mr. Brown to approve the variance. We'll take a roll call vote. Mr. Wilson,
Aye.
Mr. Brown,
Brown, aye.
Mrs. Dryden,
Dryden, yes.
Mr. Welch,
Welch, yes.
Mr. Anderson, yes, it's approved. Thank you, Mr. Good.
Thank you.
Max just sent out the findings of fact and conclusions of law. So let's take a quick look at those.
Mr. Chair,
Yes.
I would recommend to the board that you authorize your attorney to actually modify number 7. It does appear that in number 7, they're trying to reference several departments of the city. But the way the sentence is reading, it sounds like there's one large Charlotte-Mecklenburg planning, engineering, urban forestry, erosion control like group. So without really getting into the finite details, if you would authorize me to just tweak that to address the actual multiple departments, I don't think that's really a substantive change, but it would just be more of a stylistic change. Mr. Chair. Mr. Chair.
It looks like he may have an unstable internet connection.
Okay. Given the situation, I would ask the board to give it a few minutes here or a few seconds, see whether we can get the chairperson back online before moving forward.
Thomas, while we're waiting, can I ask, what happens if the owner, like 10 years down the road, doesn't meet all the expectations that we have here?
Great question. In regards to the situation the city is granting the variance with these conditions.
Uh-huh.
So they have to abide by those conditions. So they were to, in essence, either avoid doing the actual conditions or willfully indicate to us that they will not comply with those conditions. Staff does have the ability to come back and address non-compliance through either notice of violations and or seeking a revocation of the variance if necessary, which is be a very extreme method if there is such a willful non-compliance that has been repeatedly documented. But at least from my experience in these situations, with the actual aspect of a dry land access for stormwater, because of the sheer cost involved and the issues, I have not been made aware of situations where a property owner has not been compliant after receiving a variance.
Okay. And if they sell the property, these same rules and apply, correct, to the new owners? They have to accept this. Okay.
Because this variance and it runs with the land, so any subsequent owner of the property, so long as that property is being used in its current condition, would then be subject to those requirements.
Okay, thank you very much.
You're welcome.
Can you hear me now? I'm back.
Yes, sir, we can hear you.
Okay. I heard your answer to your question, Thomas.
Excellent. Just want to verify again for purposes, what was the last thing that you heard before that response to the question?
I heard you say that you wanted to revise number 7, and I authorized you to do that, and then you started to say
that was it. Yeah, that was it. That was the main thrust of the question was authorization for number 7, and then I've answered the other questions as well. So I think you're caught up with our current process. Right now, I would say to you, Mr. Chair, it is open for any further revisions and or a motion to adopt the proposed findings or a motion to revise the proposed findings.
All right. Thank you, Mr. Powers. So is there a motion? Is there a motion to approve the findings of fact and conclusions of law?
Motion to approve the findings of fact and conclusions of law as amended.
I second that. Dryden.
So we have a motion by Mr. Brown and a second by Mrs. Drop to approve the findings of fact and conclusions of law as amended. We'll take a roll call vote. Mr. Brown.
Brown, yes.
Mrs. Dryden.
Dryden, yes.
Mr. Welch.
Welch, yes.
Mr. Wilson.
Wilson, yes.
Sanderson, yes. So the findings of fact and conclusions of law as amended are approved. Our next case is case number 2020-076.
All right, the next case is a variance to allow the construction of an in-ground swimming pool within the established front setback. And I'll give you a minute to look over.
Max, will you please send out the findings of fact and conclusions of law for this case?
Yes, I'll do it now.
And Douglas, you want to go ahead and sit on this case as well, please?
I'm sorry, Rick, were you talking to me? This is Douglas.
Yes, will you sit on one of the 5 board members for this case, please?
Yes, I will.
Okay, thank you.
Mr. Chair.
Yes, sir.
Before we move forward, there does appear to be a question, and I'm more or less directing this to staff and not necessarily to the board. There was a question that appears to come forth on this particular case where there's an indication that the petition on the website may be different from this case. So I would ask Lisa, Max, or Shad to possibly respond to Mr. Henderson, who's actually commenting that there's maybe a different application for this case. I'm not sure if that's correct or not, but I at least want to bring that to staff's attention, being that we are discussing this matter right now.
Yes, I have responded to him privately. I believe he was looking at the rezoning cases, which follow the same numbering system as the zoning board of adjustment cases.
Okay. I just want to make sure that was addressed just before we move forward. Thank you.
Also, I just have been informed we've received opposition on this case, so this will need to be taken off of the recommendation agenda. So we could move straight into the 2020-078. That's agreeable.
Do we need to do anything, Thomas, other than moving? I mean, I know we need to move 7.6 to the agenda based upon there's a opposition. Can we just
not
go
believe
ahead
you-
and do 7.8 now instead of 7.6?
Yes, sir. I do not believe there's a vote necessary at the board. I think you can just go ahead and direct staff to kick off 7.8.
All right, and we're going to go ahead and move case 2020-076 to the regular agenda. Since there is a speaker in opposition, and our next case that we're going to hear under recommendation agenda item will be 2020-078.
Okay, 2020-078 is a commercial transitional setback variance. The applicant is requesting a 7-foot 3-inch variance from the required transitional setback along Westmoreland Street to renovate an existing structure. And I'll give you a minute to look at your findings.
Go ahead, Lisa.
Okay. The project is located north of Westmoreland. Government Exhibit 2 is the zoning map. The zoning is I-1 light industrial. Government Exhibit number 3 is an aerial map of the property. Government Exhibit 4 is a close-up aerial map of the property. And Government Exhibit 5 is the background of the property. The building and site were constructed in 1957, and the building on the lot is an existing non-conforming building. And the existing building currently encroaches into the transitional setback completely. And that's what's shown in yellow between the blue dashed and red dashed lines. And then it also encroaches about 7 inches into the existing right-of-way. It's not shown on this plan. They're planning to demolish the building and then rebuild and move back that encroachment so that it's a little bit more compliant, so that it's only encroaching into the transitional setback, but it wouldn't be located in the existing right-of-way. Exhibit number 6 is the variance request. In order to, they're not demolishing the entire structure. They're just adding a second story and demolishing a portion of the front that encroaches into the existing setback and transitional setback. So they need a variance to do this because they're not allowed to build within the transitional setback area at all. So the variance request is for 7 feet 3 inches from the required transitional setback. The application says 17 feet, and that's because the applicant was unaware that when a site is, the location is bounded by I-85 and Route 4, you can drop that proposed right-of-way down from 50 feet to 40 feet. So they put 17 feet instead of, it would actually just be 7 feet 3 inches needed. Government Exhibit 7 is considerations. This property is part of the Bryant Park Land Use and Streetscape Plan, and that was implemented in 2018. You can see an aerial photograph of 2017 versus 2018, and you can see the road improvements and the bike lane area. Charlotte Department of Transportation staff has indicated that they support the proposed request. Government Exhibit number 8 is a consideration that the proposed structure will fit into the character of the area. There's a elevation of the existing structure and then a conceptual elevation of the proposed structure. Government Exhibit number 9 is another consideration that it will be further set back from the existing right-of-way. And also, there's existing parking. You can see in the lower right picture that's coming down. There's maneuvering area and parking area in the right-of-way area and the setback area. So they're moving that out so that there will still be some in the transitional right-of-way. It will be more compliant. Exhibit number 10 is another consideration that there are other non-conforming structure encroachments along Westmoreland Street. And you can see them when you look at the aerial photographs. The existing building subject to this variance is outlined in the light blue. And then you can see that the other properties surrounding it have encroachments as well. Government Exhibit number 11 is a front view of the property. The end of my presentation if you have any questions.
Just for the record, it's Westmoreland Street, not Westmoreland.
Oh, was I? Okay.
No worries. Just want to make sure the court reporter had it right. So, is there anyone who wishes to speak in opposition to this case? Sir Max, we hear anything from anybody?
We do not.
Okay.
Sorry, we do not have anyone signed up to speak to this case.
Okay, thank you. Are there any questions? Any questions from staff or for staff? Hearing none, is there a motion?
This is Dryden. I make a motion to approve the variance.
This is Brown, second that.
We have a motion by Mrs. Dryden, a second by Mr. Brown to approve the variance. We'll do a roll call vote. Mrs. Dryden?
Yes.
Mr. Brown?
Brown, yes.
Mr. Wilson?
Wilson, yes.
Mr. Welch?
Welch, yes.
Sanderson, yes. So it's approved. Let's look at the findings of fact and conclusions of law. Based upon your comment that the application showed it as 17 feet 3 inches, but it's actually 7 feet 3 inches, do we need to change the numbers? Was it number 16 on the findings of fact? Or do we need to have an explanation? I didn't see an explanation in there about the.
Yeah, I would change it. I tried to change them all, but I must have overlooked.
Mr. Chair, I also concur with that recommendation that we should change it in the actual opinion.
Do we just need to add a sentence on to number 16 saying that to explain that the difference is the 10 feet based upon the reduction of the right of way due to the being adjacent to State Road 4 and Interstate 85?
My recommendation would be that we would actually say that it's only 7.3, and then add your sentence, Mr. Chair, to explain why it's not the full 17.
Okay.
The reason I would say that is simply because the actual initial request is for 7.3 feet. And if we happen to have a decision that talks about it from the 7.3, I think that would be consistent all the way through. However, if we reference it as 17 and then explain it, that may make it a little bit more confusing as to really what the request was about.
Okay, so would you change 16 to say the applicant is requesting a 7 foot 3 inch variance?
Yes, sir.
Okay.
And then I would add your sentence about the actual additional 10 feet staff already accounted for because of the property's proximity to I-85 as well as Route 4.
Okay. I like your wording better than mine, so hopefully the court reporter got that and we can make that change. At least it got the note.
If you can just give me a moment, I'm going to send this to everyone so that way you can see the exact language that I would propose. One moment, please.
Thank you, Thomas.
Not a problem, sir. Just one moment for me, please.
I didn't have any other changes to the findings of fact and conclusions of law.
If you will look in the chat, I sent this out as the proposed number 16. The language will be the applicant is requesting a 7 foot 3 inch variance from the required 20-foot transitional setback along Westmoreland Street to renovate the existing structure. Staff has accounted for 10 feet due to the site's proximity to I-85 and NC Route 4.
All right. Thank you, Thomas.
No problem. Just want to make sure everybody can actually see it and not just hear it. I would like to ask, Mr. Chair, if possible, for Lisa to verify that we're meaning State Route 4 and not some other designation.
State Route 4.
Thank you. Mr. Chair, if you were to move to take a motion on adopting the proposed findings, I would ask that any member of the board who makes that motion just account for this proposed language that I sent out to everyone.
All right. Is there a motion from the board to approve the findings of fact and conclusions of law with the revised number 16 that Mr. Powers has sent out to the board?
I make a motion to accept the finding of facts with the amendment to number 16 as Mr. Powers has written.
Thank you. We have a motion by Mrs. Dryden.
Second.
We have a motion by Mrs. Dryden, a second by Mr. Brown to approve the findings of fact and conclusions of law, including the amended number 16 that Mr. Powers sent out to the board via chat on the WebEx. We'll take a roll call vote. Mrs. Dryden,
Yes.
Brown,
Brown, yes.
Mr. Wilson,
Wilson, yes.
Mr. Welch,
Welch, yes.
Sanderson, yes. So that's approved. Okay. Our next case on the recommendation agenda is case number 2020-081. However, I understand from Mr. Oliver that there is a speaker against. Is this correct?
That is correct.
Based upon there being a speaker against this case, this will need to be moved to the agenda as well. So we don't have any more cases on the recommendation agenda. So now we will move to the regular agenda items. It's 9:55. Mr. Brown, you need to leave at 11. Is that correct?
Yes, I've got a hard stop at 11.
Okay, and Mr. Wilson, you have a hard stop at 11:30. Is that correct?
Yes, that's correct.
All right, let's see if we can get through a couple of these cases before you need to leave, Mr. Brown. Let's do, I guess we'll go back and do case number 2020-076. Mr. Wilson, if you can participate on the board for this case.
Yes, I can. And one thing, Mr. Chair, I will have to recuse myself for case number 2020066, by the way, when we get there. Just want to give you a heads up on that.
Okay. So let's do case 2020-076.
Okay, this is a residential accessory structure variance. The applicant is requesting a variance to allow the construction of an in-ground swimming pool within the established front setback. And I'll give you a minute to look at your findings.
Max, will you send out the findings of fact and conclusions of law?
They're on their way.
All right, thank you. I just got it. Thank you. Okay, Lisa.
All right, government exhibit number 1 is a vicinity map of the subject property. Property is along Carmel Road to the north. Exhibit number 2 is a zoning map of the property. Property is zoned R3 single family and area surrounded by other R3 single family zoned properties. Government exhibit number 3 is an aerial map of the subject property. You can see that the property is located on a cul-de-sac. Government exhibit number 4 is a close-up aerial of the property. Government exhibit number 5 is the background of the property. The property was subdivided. One second. Okay, the property was subdivided in 2006, and it was part of this Tufton Bray subdivision. It's kind of triangular shape. And the home was built in 2008. Government exhibit number 6 is the variance request. The property actually fronts on Carmel Road, but the home is oriented towards Tufton Bray. So the right side of the property faces Carmel Road, and there is tree save area along Carmel Road and a 30-foot setback from the right-of-way of Carmel Road. And then there's yard space. The applicant would like to put a pool in that yard space. So they're requesting a variance to allow a pool in the established setback created by that building line of the home. Staff does support the proposed request. Government exhibit number 7 is a consideration that the established setback area to the side of the home and in the established front yard is not easily visible from the street. There's building walls and vegetation along both Carmel Road and Tufton Bray. Government exhibit 8 is further considerations of site constraints, including tree save area and easements. So along Carmel Road and Tufton Bray, there's easements for us and utilities. In the rear of the property, there's tree save area and then parking area and also a retaining wall. And then over on the right side of the property, the home is built close to that 5-foot side yard, so there wouldn't be any room for a pool in that area. So the established front setback becomes the only available space on the lot for a pool to feasibly be located. Government exhibit number 9 is the consideration of the orientation of the home. The home faces Tufton Bray, and the right side faces Carmel, as previously stated. Government exhibit number 10 is a photo of the property. And that's my presentation if you had any questions.
So Lisa, can you show me a figure that shows where the proposed pool is supposed to be located?
On government exhibit number 6, the pool is supposed to be located, if you look in that red dashed area, that's the area shown to the right, just in a closer up view. So you can see that the pool is between the tree save area and the home.
Okay.
And the front yard.
So it's between that octagonal shaped, roughly octagonal shaped tree save area and that side of the house.
Yes.
Okay, thank you. Are there any other questions for staff from the board?
When did the orientation of the house change? Because was the original house, was it ever on Carmel Road, the front of the house?
No, when the home was built, it was built facing Tufton Bray.
So why is it called the front yard then?
Because it's located along Carmel Road, and it also shows that on the plat. And whenever there's a setback on the approved subdivision plat, that supersedes any zoning setbacks.
So evidently the developer changed his mind. I guess I'm assuming that when he built the development, I don't know. I'm confused about why it's considered a front yard. It's really kind of funny. Okay, thank you.
Are there any other questions for staff? All right, are there any who is present for the applicant?
The homeowner is present to speak if he would like. And Mr. Quillen, you can mute and unmute yourself.
Because you'll need to be, I need to swear you in before we have any questions or any discussion. So, Mr. Quinlan, are you able to speak now? Max, is he able to get into the conversation?
Can you hear me?
Yes.
Okay.
I'm sorry. Yes, I'm ready to go.
All right, Mr. Quinlan, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right, thank you. Do you have any questions for staff, Mr. Quinlan?
No. I think the issue is that our actual side yard is misclassified as a front yard. And we're just trying to build a pool in the actual side yard of the house.
Okay. All right. Are there any questions for the applicant from the board?
Have you? This is Terry Brown. Have you tried to address the issue of the classification of the orientation of the home with city staff? Like, what process have you gone through on that?
Just this is kind of the process. We were pretty blindsided by the rejection of the permit, so we applied for the variance, and that's been our sole approach to address the issue.
Okay, thank you.
All right. Mr. Quinlan, do you have anything else before we get to somebody that has a question about this?
No, well, I think there's three things, and clearly we're not trying to build a pool in the front yard of the house. We're actually trying to build a pool in the actual side yard of the house. The second issue, I think, is that because of the walls in the vegetation on the side of the house, it's really not. And I just think it seems to me that what we're trying to do is within the spirit and intent of the ordinance. If I'm understanding the ordinance as it's applied here, it's really trying to prevent people from putting a pool in their front yard. And if the variance is approved, we'll be putting the pool actually in the side yard.
All right. Thank you, Mr. Quinlan. I had a question for Shad or Lisa. So is there a way to change the classification to that area as being a side yard versus a front yard? And isn't the front yard based upon the way the house is oriented towards the street? I guess I have two questions.
Yeah, the problem is that the Carmel Road is shown as the front setback on the approved plat. Even though the applicant built the building in an odd orientation facing Tufton Bray, as you can see on Exhibit 6, If you changed the orientation so that Tufton Bray is the front, that 5-foot side then becomes a required 45-foot rear yard, and all of the, about half of the house is non-compliant.
Oh, okay. But is the house addressed as a Tufton Bray address, or is it addressed as a Carmel Road address?
It does have a Tufton Bray address. That's separate.
Sorry, I didn't hear that last part.
So the addressing is separate from zoning, but it does have a Tufton Bray address.
Okay. So essentially, this house has 2 front yards.
Or it's Tufton Bray, but the front is actually.
Okay. All right. Max, who is the person who wishes to speak in opposition?
We have Mr. Charles Henderson, who is a neighbor to the applicant, and he is
Okay.
on line net.
All right, Mr. Henderson, before you start, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. For the court reporter, please state your name and address, and then you can tell us what your position is.
Okay. Charles Henderson. My address is 2804 Carmel Road, Charlotte. My position is really not in opposition. I wish Mr. Quinlan would have approached us directly. And we are located, my family lives in the adjacent property on Carmel. So just to the right, if you're looking at the house from Carmel Road, we're the next property over. So in that map, it's just to the north there. So there's a couple things, and some of them have just come up in the conversation. There's a long history with the property that I went through when I acquired my house last year. There are actually significant deed restrictions in place for the Knapdale Properties Limited Subdivision, which includes my house, and the house is located along Knapdale Lane, which heads sort of northwest or west off of Carmel there. That subdivision actually includes Mr. Quinlan's property. So for starters, there's actually different setbacks that are based on those restrictions that are somewhat in violation, not to mention the subdivision itself, which you could argue that portion of it carved out for a cul-de-sac is not really a violation. Needless to say, that's not my issue. I'm just coming into owning this property and trying to remedy some years of not well kept by previous ownership. It was a foreclosure back in the Great Recession, and it hasn't been well loved. And I just want to continue the process that I've started in rehabbing the property, and that is partially why I'm here, or mostly why I'm here, I guess, or partially I'd say. Mostly I'm here because of my 3 children that play in my front yard, and in fact, your aerial doesn't show that many of those trees that are closer abutting to Mr. Quinlan's property are now a nice play area that my children spend a great deal of time in. I see Mr. Quinlan's plan to include a aluminum 48-inch fence around the pool. I'm not sure if that violates the restrictions of the deed restrictions of either his subdivision or ours. I think it does. I'm almost certain that the non-enclosure of the pool equipment within a brick wall would violate. I'm very confident on that one. I'd say 99% sure. So I'll have to check. And I know that's not really your purview here, but that's something that is outside of this. Mostly what I would ask is that you look at the remainder of the house, multiple photos, in fact, presented today, that show the brick wall that surrounds his entire property, except for the property line abutting my residence. And I would just ask that same wall be continued to properly screen and avoid, my children even seeing the pool. Not to mention the privacy that Mr. Quinlan would probably enjoy. Not to mention the sound that will ultimately bellow off of what is actually a 3-story residence located on his property, which I don't know if that's another violation, but that's all in the past. Like you were saying, the rear of his property comes right up within 5 feet of my property line. There's already been, you know, quite a bit of a lack of privacy caused by the irregular development of that parcel, whether or not it was in any violation at the time. And all I would like is that any continued work there include, you know, only something that's fitting with the neighborhood and Mr. Quinlan's property itself, which would be to continue a similar screen or wall structure to include encompassing the pool and the pool equipment. In which case, I'm more than happy to give my full support to the petition.
Thank you, Mr. Henderson. Are there any questions for Mr. Henderson?
I just want to make sure your property is to the right of, looking at this map, to the right.
It's up on this map.
So we're looking at city government exhibit number 3, and your property
Correct.
is listed as the 2804 property. Is that correct?
That's correct. So it's to the right, you know, it's northeast of that property.
So it's 2804.
Yes. So my property similarly does not access from Carmel Road, but it does have a Carmel Road address. And the setback for this prior subdivision, that includes multiple deed restrictions in addition to the setback beyond zoning, is actually 100 feet front. So there's a potential, you know, that the house, and you can see that the house looks like it is actually aligned with that deed restriction, like mine is, at the 100-foot setback that's imposed upon these properties that are along Carmel Road, despite the existence of the Tufton Bray court may or may not even be allowed. It might have been a violation. I'm under oath, so I can't speak to that for sure, but I would say that in my research, I do not believe that I could have done something that was done with this property to my own property. So that previous action, I don't think should necessarily, you know, allow something as future action that, you know, I think further diminishes my property in particular. I don't really think there's anyone else that is impacted by this, namely because every other side of his property is enclosed by a wall. So I just would ask that the same walls continue.
Thank you.
Are there any other questions for Mr. Henderson?
Is it appropriate to ask Mr. Quinlan at this time if he would be amiable to continuing the wall around his property as opposed to the aluminum fence that he plans to put around the pool?
Yes. Mr. Quinlan?
I would not be amenable to extending the brick wall. You know, I'm really proposing a fence that's being used throughout the neighborhood, and I believe it's a very similar fence to. I'm sorry, is it Mr. Henderson?
Yes.
I believe it's a very similar fence. One point that I would like to, I just noticed it on the deal, that the pool equipment is actually not going where it's showing on the deal. It's going to be by the brick wall that fronts on Tufton Bray Court. So it'll be quite a bit farther away than it's showing on the plan. But, you know, we're certainly going to make an acceptable fence. It's commensurate with all the other pool fences in the neighborhood.
I'd have to respectfully disagree. My fence is a wrought iron fence with masonry pillars, so it's not a full brick wall, but I would challenge Mr. Quinlan to provide an example in the Knapdale Properties Limited subdivision, which he is a part of as well as his plat, that you find a aluminum fence that adjoins to a brick wall as a continuation. Anywhere within the development or even the neighborhood. For that
Gentlemen, let me just weigh in as the attorney for the board in this regard. Both of you have brought forth their proposals. The board will consider those proposals in making its decision. But I do ask that both of you refrain from actually commenting over one another in regards to the proposal.
Yes.
Okay, is there anything else from the city staff?
Mr. Chair,
Mrs. Shad?
if I may ask, if the board wishes to consider this request about a actual brick wall, I do want to make sure that staff has at least provided you with information as to whether or not they have deemed this to be something that is worthy of consideration. But I do not want to have as a board to consider this request and then to approve it, and then staff come back and say that this is not permissible under the ordinance. So even though it's outstanding for a request, I would like for at least staff to weigh in whether this is possible or not as you deliberate and consider the request and the counter request as part of your deliberations.
Thank you, Mr. Powers. Lisa, Shad?
Yes, 5 feet is permissible. That's possible.
So there is sufficient room and zoning it would be allowed under the current zoning regulations for a brick wall to be constructed along that property line? Lisa, Shad, is that correct?
Correct, yes.
Okay. Is there any other information that staff has or
No, not
comments?
No.
All right, Mr. Quinlan, is there anything else you would like to present?
No, I think that's it. Like I said, I mean, we'll certainly put an attractive fence in. It's the fences in my neighborhood are all the aluminum variety, but we'd be we're gonna make something attractive. So I guess that's it.
All right, thank you. All right. Is there any other question from the board for the applicant, staff, Mr. Henderson, before we close the hearing?
I mean, I would just point that I don't believe that the prevalence of aluminum fences in the neighborhood is as presented.
Okay, thank you, Mr. Henderson. Anything else? Any questions from the board for anybody during this case? Hearing none, I'll close the hearing then. So we'll go ahead and start deliberations. This is you're closed. The hearing is done. Is closed currently. We're going to begin deliberations. Please refrain from making any comments, anybody other than the board or Mr. Powers, during the deliberations. You may stay present and remain present and listen quietly as we discuss and vote for this case. So who wants to start on the board? Mr. Brown? You just happen to be the first picture I see on the list.
No worries. I'll say that at this point, from hearing both sides of it right now, I'm leaning towards denying this variance. While I'm looking at it and seeing the evidence presented, I'm just not seeing the basis for it. And I was, at first I was thinking that maybe if we're going to flip it over and fix which side it's going to be the side yard versus which side is going to be the front yard, we might be able to make something work that way. But now hearing half the house would be out of compliance if we were to change the side yard. I'm just not seeing how we can stay consistent in our reasoning for other cases and make this work. But I'm open to hearing what the rest of the board has to say about that as well.
Okay, Mrs. Dryden.
I am conflicted. I would like to, looking at it, I mean, the orientation for the house, even though the plats, which this homeowner bought this home, he had nothing to do with the plats that were developed. And the plats show Carmel Road, and whatever the developer did, whether it was in code or without code, or what the zoning rules were at the time that this was built. But I see the orientation. It's got a Tufton Road address. So I don't have a problem with that being identified as a side yard. I just see the conflict in the neighborhood between what Mr. Quinlan, what his description of aluminum enclosure around the pool is, compared to Mr. Henderson's concept of what an aluminum fence looks like. I don't have enough experience with pool enclosures to know what that looks like. Are there no tree, I thought there was a tree buffer between those two pieces of property. Am I correct in that, staff?
We'll have to open the case hearing if we need to ask staff.
Oh, okay, never mind then. All right, well.
If you want to
yeah,
ask the question, we can reopen it and ask the
Well,
question.
no, just looking at all the pictures, it looks like there's a tree buffer. At least that's what the original thing said.
I would agree. Looking at the pictures, it looks like there's a row of trees.
Correct. Now, you know, the size of those trees or whatever. But, I mean, I don't want to get into a squabble between neighbors. And, you know, I would hope that you could come to some kind of agreement and continue the brick wall if that's what the neighborhood, I mean, I see the wall around some of the other pictures around the neighborhood that abuts Carmel Road. And have some private discussions about what this looks like. But I would like to see this side yard be used for the pool if we can come to some agreement about what the aluminum enclosure is going to look like. Or some commitment, you know, to make it as pretty as possible, maybe planting some more trees or some more shrubbery around it after it's constructed to, again, increase the buffer. Those would be my considerations for this.
Okay.
To make it amenable to the other neighbor.
Okay, Mr. Welch.
As Mr. Brown stated, I'm leaning towards denying it because of, like I said, being consistent with other cases that we listened to, and you know, as Ms. Dragon said, I'm not an expert at pool enclosures, so but an aluminum fence coming out of a brick wall doesn't seem too appealing to me. But you know, like she said, if they can come to some type of agreement to extend that wall, you know, that's between neighbors. So not getting into that, but as of right now, don't have enough of information or to approve this right now.
Okay. Before I get to Mr. Wilson, Mr. Powers, may I ask a question to you?
Yes, sir.
The what authorization or what leeway does the board have as far as conditions for a case of this nature for requiring, I guess, enclosures or types of enclosures?
Great question, Mr. Chair. I was actually going to wait till all of the board members have offered their points before I weighed in that regard. I think the question you're asking is one that I wanted to address, but I did not want to sway the board's opinion and or their initial thoughts. So if
you can wait if you want to answer, because the reason I asked the question because we've heard from two different board members. I still have one to go through.
Yes, sir.
To have asked that question, so that's why I wanted to ask the question.
If we could finish the initial round of discussion, I would then be able to weigh in on that very question, sir.
All right, thank you, Thomas. Mr. Wilson, your thoughts?
Sorry about it. I was trying to find the mute button here. Just like my colleague said, I am leaning towards denying the variance just based upon the cases that were brought to us beforehand. A little bit conflicted because I know that this is a residence and they're trying to expand on it, but just based upon listening to my colleagues and looking at the variance request in more detail, I'm leaning towards denying the request.
Okay, thank you.
Mr. Chair, what other cases are they referring to when they say that we turned down, or I don't know what cases those are, at least not since I've been on the board.
Actually, that's one of the points I will definitely address, was once the chair has actually given his thoughts on the case, I wanted to address that issue about the previous cases as well.
Thank you, because I don't know what they're talking about when they say previous cases.
Not a problem.
Thank you.
Mm-hmm.
All right. My initial thoughts were I was leaning towards approving it. And I don't think it's within the board's purview to get into the, I guess, the homeowners association subdivision requirements, deed restriction requirements that are placed upon it by the development of subdivisions. We're supposed to look at land use. The purview of this board is the use of the land per the current zoning requirements. And if there is a non-conforming property and they're changing it to make sure that it's being brought into compliance with the current zoning requirements. So that's my initial thoughts, because I was leaning towards approving it. And I understand the concerns about the fencing. I understand the concerns about the brick wall, but I believe that the property owner has the right to put in the pool. And this is a unique situation because of the configuration of how this property was surveyed and broken out in the subdivision, and facing how they set it up essentially with 2 front yards instead of a side yard. So that's my initial thoughts. I haven't made a final decision yet.
Mr. Chair, if I may.
Yes, sir.
Members of the board, there's a few items here I think I need to discuss with you in full to help you kind of frame the discussion and ensuring that we're evaluating this under the requirements of the law. Number one, and again, when we're looking at and evaluating a variance, we're looking at, again, certain factors in that regard, and there are generally 4 factors. Whether the unnecessary hardship results from strict application of the ordinance, whether the hardship results from conditions that are peculiar to the property, whether the hardship results from actions taken by the owner or the applicant, and whether the actual requested variance is consistent with the spirit, purpose, and intent of the zoning ordinance, and that the public safety is being secured or substantial justice is being achieved. So as you are evaluating this actual request, the primary request that's before you at this time is the actual pool structure. So as you're looking at whether or not to grant a variance, it is the pool structure is really where you're looking at those 4 factors to determine whether or not you should grant the actual variance for the pool. Now, the secondary issue that has come forth in this actual case today has been the question of whether or not a fence or an actual brick wall should be extended around this actual additional accessory structure to ensure that the neighbor has some additional privacy. I think that secondary issue should not be addressed until you have decided whether or not you think this actual variance request meets all the necessary factors. If you believe it does meet the necessary factors to grant a variance, thereby allowing the actual pool to be built, I think you can then move to the secondary issue as to recommending or conditioning that a brick wall could be built or should be built, or that there should be additional vegetation to separate the actual properties in question. The secondary issue in that regard is only a request from the additional property owner. It is not something that has to be attached to this actual variance if you were to decide to approve it. The chair also alluded to my third point that I wanted to address today, which is this board nor the city of Charlotte has the ability to enforce any of the private covenants in regards to this development or the property. If the 2 adjoining property owners have issues in regards to those covenants not being adhered to, in regards to setbacks, placement of accessory structures, vegetation or other actual buildings, that is a matter between those two individuals, and they would need to seek any legal counsel, private of course, to adjudicate their rights before a judge in that regard. Staff nor this board would be able to get into that and to declare who is right or who is wrong. I do think that questions have arose as to the secondary question, and I go back to secondary question being the wall, whether or not there is sufficient evidence to indicate that a brick wall is the predominant factor in the community, or whether aluminum fencing is the predominant factor in the community. In this instance, if the board cannot consensus as to the actual facts in that regard, I do believe that you have the ability to either postpone this hearing to obtain that information before making a final decision, or if you wish to move forward and approve the actual variance, you can do so at this time without actually considering the secondary issue. Now, again, I want to give the overarching thought that this is only if you wish to approve the variance that you would go down this secondary path after finding all of the factors necessary for the variance has been met. I think there's a fourth issue too, and I want to make sure we address this from a factual standpoint. And I do understand the thoughts of orientation versus actual designation. So as I understand from the board, there's an orientation of the house towards Tufts Bray Court as being what most perceive to be the front yard. The front door is kind of oriented towards that, where people will go in and out of the actual property. But as staff has alluded to, they are bound by the designation on the actual plat that says that the front yard is again towards Carmel Road. So when we're talking about the aspect, even though that designation is different from the orientation of the home, I want to make sure that we're talking about it from the standpoint that that designation of where the pool would be the front yard in that instance, and not necessarily a side yard. And the reason I'm bringing this forth to you all at this time is simply because depending on what decision you were to make, I want to make sure that if this is subject to any further review, that we are ensuring that anyone in the judicial branch will be able to look at your transcript and know that we're all consistently applying the same terminology, and we're also approaching this from the same viewpoint, and not making it a distinction that is not appropriate in an instance. So I just kind of want to make sure I just at least frame this from the orientation that everybody is alluding to, which is Tufts Bray, and I do not disagree that the house does appear to be oriented towards Tufts Bray, but the zoning designation has it where the front yard is towards Carmel Road. So those are the four items I just wanted to make sure I just bring forward to the board as part of your discussion and provide that guidance to you. But I will turn it back over to the chair as well as the full board for further discussions and or questions that you may have of me.
So I don't know what cases, Mrs. Dryden, to get to your answer to your question.
Sorry.
I don't remember any cases of, and I've been on the board, I don't know, 4 or 5 years now, of any cases that we've talked about with a pool in the front yard, which technically this will be a pool in the front yard based upon the designation of it being the frontage to the Carmel Road.
So Mr. Sanderson, thank you. I meant to address that quick point as well. Sorry about that. So in regards to the factors that you're looking at, you're applying these factors to each individual case. You are looking at the individual circumstances of this case as you're evaluating those factors. Previous cases that may have been decided by the board should not be an overarching precedent for the board in that regard. If staff believes that there is a consistency in regards to this case versus another case, then that evidence and that requirement would have been on staff to bring that forward to the board to show that consistency across the organization and across the city as a whole. If you're evaluating this based on another case that you're thinking about, I would definitely caution the board against that. But if you believe that is readily apparent that this needs to be compared to that case, I do ask and request any board member to bring forth the particular circumstances and or case number that you can recall and address for the chair to then ask staff to provide that information for the full board to be aware of it as part of the discussion deliberation. If the board makes a decision based on another case that other members are not aware of, that does give a
Somebody put us on hold. Max, can you figure out who that is?
caller 3.
Sorry, got it now.
Not a problem. Nice elevator music, to say the least. As I was saying, if someone is aware of a case or circumstances that they believe definitely influences their opinion of this particular case, I would ask for those individuals to bring forth the factual matter, address, or something of that nature, so other board members can be aware of that, be able to discuss it, the pros and cons, and staff can bring forth any type of decision letter as well to make sure everyone's fully informed of that case that may be influencing your thought process. The reason I caution you on that is simply because if the board were to vote and someone is indicating another case has influenced their decision, there may be an argument of whether or not it is arbitrary capricious in regards to your decision today. So that's the thing I meant to bring forth. And Mr. Chair, I appreciate you at least alluding to that. So I apologize to Board Member Gray, for now addressing that point.
Thank you, Thomas. All right, is there any other deliberation that we need to make based upon Mr. Powers' explanation of what we need to do? We know we need to meet the 4 criteria. That's always been the case for this board, is to be able to meet the 4 criteria.
Well, I feel like this is a very unique situation, and I understand the designation on the plat, but this current homeowner had nothing to do with that initial, and from his sworn testimony, he did not even know that this was an issue until they got ready to do the pool and ask for the permit. So he was not even aware that that was the front yard. So in this discussion, I would vote to approve this and then maybe talk about the secondary issues, maybe some suggestions, but I don't see a reason to deny this variance just because the designation on the plat says that's the front yard. Because there is a wall, we've seen pictures of that. It's completely hidden from Carmel Road. So I would vote to approve it.
And also looking at Government Exhibit number 6, the fencing that is proposed on that exhibit is a compliant with the pool code for putting in a pool.
Correct.
48-inch black aluminum pool code compliant fence is what it says. So as long as it's compliant with the pool code, we'll get to the secondary issue if we have to.
Correct. I agree with you. And I'm not pushing to address the second issue, but I think we should, as far as I'm concerned, I would vote to approve this.
Okay. Mr. Brown or Mr. Welch or Mr. Wilson, any other comments?
No comments on my end.
None for me right now.
None for me.
All right, then is there a motion?
This is Dryden, and I make a motion to approve this variance.
Okay.
So Brown, I'll second that motion.
All right, so we have a motion by Mrs. Dryden to approve the variance, a second by Mr. Brown. We'll do a roll call vote. Mrs. Dryden?
Yes.
Mr. Brown?
Brown, yes.
Mr. Welch?
Welch, yes.
Mr. Wilson?
Wilson, yes.
Sanderson, yes. So the variance is approved. So do we want to address the secondary issue or leave it with the plan, as I said, on government exhibit number 6 with the 48-inch black aluminum pool code compliant fence?
I don't wish to address a secondary issue. Based on what Thomas said about us not getting involved in neighborhood covenants, and if the 48-inch black aluminum pool code, the fence is compliant with the pool code, then I don't think it's our business to get involved in neighborhood covenants.
I agree. That's not our purview.
All right. I would agree as well. So then we need to look at the findings of fact and conclusions of law and see if there are any revisions that need to be made. I didn't see any revisions, but
Okay, I make a motion to approve the finding of facts as written.
I second this, Douglas Wilson.
all right, we have a motion by Mrs. Dryden, a second by Mr. Wilson to approve the findings of fact and conclusions of law as written. We'll do a roll call vote. Mrs. Dryden,
Yes.
Mr. Wilson,
Yes.
Mr. Brown,
Brown, yes.
Mr. Welch,
Welch, yes.
Sanderson, yes. All right. Next case will be 2020-081. Mr. Brown,
Is already
you
there.
need to leave in 15 minutes, so you probably
Ignorant.
should not sit on the board on this case.
Okay, that's fine.
Thank you for being here today.
Thank you all. You all have a good day.
All right, thank you, Terry. So, and Mr. Wilson, you need to leave in 45 minutes, correct?
Yes, that's correct. And I'm recusing myself from the next agenda item as well.
Yeah, it is 6:06. If we won't be at 6:06 probably before you need to leave. I'm just trying to figure out if 45 minutes will be sufficient to get you to listen to case 081, or if we should go ahead and just have Mr. Floyd and Miss Allen sitting on it. Well, we'll need Mr. Floyd to sit in on the case. Let's go ahead and have Miss Allen, if you're available to sit in on the case.
Yes, I'm here.
Okay. Can we take like a 5-minute break just so I can stretch my legs? Is that okay with everybody?
I would appreciate that. Thank you.
All right, so let's take a 10-minute break. Let's come back it's now 10:47. Let's come back around 11:50. I mean 10 or 11 o'clock. Let's just say 11 o'clock.
Max, if you can mute everyone during the break.
Thank you. We'll come back at 11 o'clock. Thank you.
All right. 11 o'clock. Yes.
Max, we ready to restart?
I believe so, if everyone's here. All staff is here.
Okay.
I'm here.
All right. Moses says she's on the phone, so. So for this case, this is case number 2020-081. We will be, the board will be myself, John Floyd, Patrick Welch, Deborah Dryden, and Emma Allen. Mr. Brown had to leave. Mr. Wilson has to leave at 11:30, which, just to be safe, let's go ahead and have Emma and John sit in on this. And this will be the board moving forward for the last three cases. Looks like everybody is back. So Lisa, let's go ahead and start. And Mac has already sent out the finding of fact and conclusions of law for this case.
Okay, this is a residential rear yard variance request. The applicant is requesting a variance from the encroachment allowance to allow a covered porch to encroach 50% into the rear yard. And I'll give you a minute to look over your findings.
Okay, Lisa, whenever you're ready.
Exhibit 1 is a vicinity map of the subject property. The property is located to the east of Park Road and north of Princeton Avenue. Exhibit number 2 is the zoning of the property. The zoning is R4 single family, and it's surrounded by other R4 homes with some R8 conditional in the vicinity. Exhibit number 3 is an aerial map of the subject property. And exhibit 4 is a close-up aerial map of the subject property. The property was subdivided by deed in 1989, according to the applicant. And also that same year, the home was built on the property. When the home was built, a deck was built on the rear of the home, and it encroaches into the rear yard 17 feet. You can see the 40-foot rear yard as the dash line right behind the rear building line of the home. And according to today's regulations, you can encroach 25% into the 40-foot rear yard with a single family home. And 25% would be 10 feet. So the existing deck exceeds that encroachment allowance by 7 feet. And that is non-conforming prior to today's current regulations. The applicant is requesting a variance. The variance request in the application was for a 20-foot encroachment, which would be 50% into that 40-foot rear yard area, which is an additional 25% encroachment allowance into the 40-foot rear yard. Staff did not support that request and asked the applicant if they would be agreeable to a variance to allow a new covered porch area to use that same encroachment of 17 feet that the existing deck uses and have a 43% encroachment into the 40-foot rear yard for a new covered patio. The applicant has agreed to the modified variance request of 18% from the 25-foot encroachment allowance for a 17-foot encroachment for a new covered patio. A consideration is that the covered patio will fit in with the character of the neighborhood. The applicant has provided photos of other covered patios in the area, and the elevations that they provided looks consistent with those other patios. Exhibit number 8 is another consideration of the lot depth of the property. The lot depth is approximately 103 feet when you measure straight back. The 105-foot property line you see on the aerial is kind of slanted. Other lot depths in the surrounding area range from about 135 to 250 feet in depth. Government exhibit number 9 is a photo of the property. And that is my presentation if you had any questions.
All right, thank you, Lisa. Are any questions for staff?
Lisa, I just want to be clear. The original patio was 17 feet and it was out of compliance, correct?
Correct.
The original deck. So the homeowners have agreed to replace it with just a 17-foot covered patio instead of an open deck, correct? So basically, we're not changing the footprint of the house except to cover the deck.
Correct. They just want a covered patio and they wanted to encroach 20 feet. Staff said that they would support 17 and the applicant agreed.
Right.
They're just covering.
Okay, thank you. I appreciate that.
Any other questions for staff? Hey, Max, the property owners are on the call, is that correct, on the meeting? Is that correct?
That's correct. The property owners are panelists, so they can mute and unmute themselves and speak.
All right. So that would be Mr. and Mrs. Ford, is that correct?
Yes, sir, that's correct. And we're both here.
All right. Let me go ahead and get you sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yeah.
I do.
Okay. Before you make any comments, please state your name and address for the court reporter, and then you can go ahead and.
Rob Ford. Sure. Rob Ford, 3030 Somerset Drive.
Jennifer Ford, 3030 Somerset Drive.
Okay, thank you. And then just present whatever information you want to the board for this case.
Sure. Thank you for your time today. So like was stated earlier, we're really just looking to build a masonry structure in effectively the same footprint as the current deck that's there with a cover over top. The reason I say effectively is we are, again, looking to go, the depth would be the same. However, the width, we're looking to go a foot or two wider. And actually, say with zoning, they actually said we could go as wide as 31 feet, which is much wider than we would care to do so. The covered porch that we are wanting to build is single story. As I said, it will be masonry connected to the home, and certainly maintain the spirit of the neighborhood with landscape around it. So there won't be a whole lot of change as far as the height off of the elevation height off of the ground. Our home was we've lived here for 3 years, and our home was part of it was subdivided off of a lot that borders on the corner of Somerset and Princeton, and was subdivided in the late 80s, I believe around 88, prior to this home being built. So that's what I have.
All right, thank you. Any questions for the property owners? Okay, do you have any questions for staff?
I don't think so.
Okay, Max, you said that we had someone who wanted to speak.
Yes, we had one neighbor signed up to speak, Michael Peter, and he is also a panelist and can mute and unmute himself.
All right, I see Michael, Mr. Peter there. Mr. Peter, before you start, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, I do.
All right, please state your name and address for the court reporter and then make your comments, please.
Michael Peter, 1125 Princeton Avenue. So I'd like to start by saying thank you to the board, staff, and my neighbors for giving me the opportunity to speak here today. I want to be a good neighbor, and I do not wish to cause harm. However, I do believe that being a good neighbor is ensuring that the precedence that is set is consistent with our neighborhood and would not cause any potential challenges for our future. So we are concerned with the precedence that this variance would set in our neighborhood, and more personally to other adjacent properties to ours. We purchased our property partially due to the privacy our lot offers. And as you look at the photos, we are not sure that the small lot in of itself creates a hardship worthy of cutting the rear yard in half. However, given what we've heard of the adjustments and the meeting of that footprint, it does not appear to us that they may be causing significant change to what is already there. However, the adjacent corner lot is similarly sized, and if they receive a similar variance treatment, it could be very detrimental to our properties. The corner lot is ripe for redevelopment, as you can see here. And this variance, if taken as precedent, could drastically impact our home, which is right on near the lot line, in terms of quality of life and privacy, which is a reason I suspect this zoning exists in the first place. So my ask of this group is to confirm my expectation that the conditions for allowance of this variance is one, that there already exists a patio footprint of non-conformance, and two, that the variance would not expand that footprint beyond the existing patio to encroach towards a neighbor's land. We were told that this would be a one-story addition. We'd like confirmation on the record so that the precedence reflects that the structures encroaching 50% into the rear yard are not appropriate and would not maintain the residential field of our neighborhood. Thank you.
Thank you, Mr. Peter. Just a quick question for you. I'm looking at government exhibit number 8, which is currently up. Which property?
Ending 6471 or 6417.
You're behind them.
That is correct.
Okay, that's just I just wanted to confirm that. And it was my understanding, Mr. and Mrs. Ford, that it'll be you've agreed with the staff's recommendation or option to construct your new patio, screened-in porch, however you want to phrase it, within the same footprint or within that 17-foot current setback that is there, and be in a single story. Is that correct, Mr. Ford?
Correct. Yes, that is correct.
Okay. Thank you. Any other questions? Any questions from the board for Mr. Peter or the Fords or staff? Okay, hearing none. Lisa, does staff have any other comments in this case?
No, no more comments.
Okay. Mr. Peter, any other comments?
No, sir.
Thank you. Mr. and Mrs. Ford, I'll give you the last word. Any final comments?
No, I think we've covered everything we want to. We appreciate it.
All right, thank you. With that, I will go ahead and close the hearing. We will now begin our deliberations. Please do not interrupt the deliberations. Only the board members can talk. If we need to, we'll reopen the case to getting additional information as the board sees fit. Let's see, Mrs. Dryden, I'll start with you this time since you're the first one on my gallery of pictures.
I don't see any problem with approving this variance since they are staying, they've agreed to the 17-foot footprint and not enlarging that, encroaching that further into the backyard. So I don't see any reason not to approve this. So right now I'm leaning toward approval of this variance.
All right, Miss Allen,
I would echo what Ms. Dryden just said. I would lean toward approving it as well.
Great, thank you. Mr. Welch.
I'm in the same. They're not, they're staying within the same footprint, so I have no problem with approving this.
All right, Mr. Floyd.
I won't belabor the point. I agree with my colleague.
All right, I do as well. Is there a motion then?
I make a motion to approve the variance. Dryden.
Second, Douglas Wilson.
Mr. Wilson, you're not sitting on the board in this case.
Oh, sorry about that.
Second, John Floyd.
All right, thank you. We have a motion by Mrs. Dryden, a second by Mr. Floyd to approve the variance with the modifications that staff recommend or provided and the property owners have agreed to. We'll do a roll call vote. Mrs. Dryden.
Yes.
Mr. Floyd.
Yes.
Miss Allen.
Yes.
Mr. Welch.
Yes.
Sanderson, yes. Okay. Let's look at the findings of fact and conclusions of law. I didn't see any changes or revisions when I went through them. Thomas, do we need to, since they're going with the modification, do we need to keep it as is, or do we just need to now make that the variance request and strike the part where it said staff finds that the variance request as proposed does not meet their criteria? Which would be the correct way?
So in regards to that information, again, that was staff's proposed recommendation for your decision letter. Your actual final decision letter will not have that language. It will say that the board finds that this variance is appropriate based on these factors. I will say, reviewing number 1 through 13 for recommendations. Sorry, actually, hold on a second. Okay, sorry. So let me modify this. Being that the staff and the actual applicant have agreed to the modified variance, then in that case, 14 through 28 would be appropriate in my mind. I would probably delete 12 and 13 definitely. And I'm not sure whether 11 should also be removed as well, because that's all talk about that 25%. And actually, one moment. Let me read this. I apologize. Okay, so, and I apologize for delaying this. So I've looked at the proposed findings of fact. Mr. Chair, I would like to ask one question of staff just to make sure how this is formatted, which is a little different. My recommendation would be to delete the 11, 12, 13, and then going to the next set of findings of fact, pick up at 15. But I just want to make sure, is that what staff is really trying to actually have the board to vote on? Or are they just really trying to have the board to vote on 14 through 28? So that will be the procedural question I would like to throw to staff with your permission, Mr. Chair.
That's fine, Mr. Powers. Lisa, Shad?
Yeah, what Thomas said at first, the intention would be to delete 11 through 13 and then keep the 1 through 10 because they're just background information.
Okay. That's what I wanted to make sure in that regard. Then my recommendation to the board, Mr. Chair, would be 1 through 10. I would pick up at number 15 and then go through 28 with your conclusions of law.
Okay, thank you. That's why I wanted to get a clarification since they were both presented here. That's why I needed to get the clarification.
Again, apologize for that. I will probably speak with staff afterwards in these type of circumstances to have maybe 2 actual proposed findings of fact, one based on just a clear variance request, and then one based on a modified variance request. So it'll be easier for the board to review.
Okay, thank you. All right, is there a motion from the board?
I make a motion to accept the finding of facts as amended. Or to delete 11, 12, 13 and pick up at 15. Does that mean we're deleting 14 also, just to be clear?
Yeah.
Okay, yes, and pick
That's
up
correct.
with, yes, pick up with 15. That's my motion to accept.
I'll second.
Okay, we have a motion by Mrs. Dryden, a second by Mr. Welch to approve the findings of fact and conclusions of law as amended by deleting 11, 12, 13, and 14. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Welch,
Yes.
Miss Allen,
Yes.
Mr. Floyd,
Yes.
Anderson, yes. Those were approved. Okay. Our next case is 2020-066 for property located at 536 East Tremont Avenue.
Next request is an accessory structure variance request, and the applicant is requesting 2 variances to allow the construction of a carport on his property. Variance to allow a 10-foot reduction to a required 32-foot setback, and a variance to allow a 1-foot 3-inch required 3-foot side yard. And I'll give you a minute to look over your file.
I'm sorry, this is John Floyd. Did the findings of fact and conclusion law go out? I'm not seeing everything.
Yeah,
Yes.
Matt just sent them. You should get them any second. I just got them.
Okay. Wait.
Did you get them, John?
Yes, I'm looking at it.
All right.
I mean, Lisa can go ahead and start if everybody else.
Yeah, go ahead, Lisa.
All right, government exhibit number 1 is a vicinity map of the property. Government exhibit number 2 is a zoning map of the property. The property is zoned R5 single family and it's surrounded by other R5 zoned properties. You can also see here that the property has frontage along Tremont Avenue and Dilworth Mews. Government exhibit number 3 is an aerial map of the property. Government exhibit number 4 is a close-up aerial map of the property. Government exhibit number 5 is the background of the property. The property was subdivided in 2015, and the home on the property was built in 2016. Government exhibit number 6 are the variance requests. The applicant would like to construct a carport in what is used as the rear of the property along Dilworth Mews Court, and there's a 32-foot setback from the curb on Dilworth Mews for the property. So any accessory or principal structure would have to adhere to that 32-foot setback. The applicant would like to place a carport in that area and also in the 3-foot required accessory side yard. And so he's asking for a request of 10 feet from the 32-foot setback for a 22-foot setback from the back of curb along Dilworth Mews, and a 1-foot 3-inch variance from the side yard for a 1-foot 9-inch side yard. Staff does not support the proposed request. Government exhibit number 7 are considerations of compliant areas for placing the structure. To the left is in yellow. The area in yellow signifies the zoning compliant building area for an accessory structure. Over to the right, you can see the red areas are where the proposed carport is not compliant with the zoning regulations, being the 32-foot setback and the 3-foot accessory side yard. And the blue and green is if they reoriented the carport or moved it further back towards a footbridge, it could be compliant with zoning regulations. Government exhibit number 8 is that there's other area homes that are compliant with the setback along Dilworth Mews. So you can see the other properties have at least 32 feet from Dilworth Mews and no structures in that area. Government exhibit number 9 is a view from Dilworth Mews. So you can see where the existing driveway is. There's a bridge over a little stream that runs through the back of the property. And that's all I had. If you have any questions.
Lisa, can you go back to the exhibit that shows the staff, that one, 7? No, thank you. So you're saying that the same size, that this figure, this exhibit number 7 shows, is that the same size proposed carport just shifted to get within the existing setbacks?
Yes, the proposed carport size is 22 by 32 feet. So what I did was just do the same size carport, reoriented, and then shifted back a little bit.
And what's the green box?
So that's just reoriented to the wide angle facing Dilworth Mews.
Yeah, the green box I don't think would be workable if they're using it as a carport coming off the driveway there. But the blue box I think would be workable based upon just the figure itself. I don't have any other information yet. Are there any questions for staff?
I have a question. What happens to the footbridge if they go with what's in the blue section, is the footbridge removed? I'm assuming, or the paved, the brick area, that's not the bridge, is it? That's just a brick paved area?
Yeah, that's just a brick paver sidewalk, I believe. But
Oh,
these were
okay.
just to show, these were just two possible ideas. They're not the only ideas. Anywhere in the yellow would be compliant, but these were just two possible options.
Okay, but the concrete drive is up in the far corner, correct? On the yellow, that's the current driveway?
Yes, you can kind of see the driveway. You're right on the left-hand side.
Yeah,
They're showing the driveway, and it is in the yellow area.
okay. Thank you, Lisa.
Any other questions for staff?
Yeah, this is kind of along the same lines as Ms. Brad's questions. At least I know you're just showing examples, but I mean, are you saying that they could build a proposed carport within the required setbacks and not have to just demolish that bridge and not have the car part of the carport being within that creek?
Correct. I'm saying that there's area to build it.
Okay.
Okay, any other questions for staff? All right, Mr. Lassiter, I see that you're on. Before you start your comments, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, will you please state your name and address for the court reporter, and you can go ahead and make what comments you want to make or presentation you want to make.
Brad, B-R-A-D, Lassiter. That'll be for 536 East Tremont Avenue.
Okay, thank you. You can go ahead and make any comments or presentations that you want.
Okay. Thank you, Chair, Board, and staff. I appreciate your time. So this is obviously for post-beam construction carport. Aesthetics will match the existing structure of the building, current main height less than the main building, obviously, as well. Access to the carport, looking at exhibit number 7, is of concern, with being options of blue or green being at the corner of the carport would not really allow existing access into the carport. So I wanted to make that aware. Green box as well as blue box impede the existing multi-decade tree as well as the root structure of a tree there at the bottom southwest corner of the existing concrete pad. I did meet with an arborist as well to go over root structure as well as canopy. He said as of now, he's basically root structure is unknown, but movement of the proposed carport closer to the stream as well as that tree probably would kill that tree or require full removal. The setback, obviously looking for 1'3" off the right, 10 off the rear. And there is already some previous mild stream bank erosion on this existing stream bank. And I think water containment as well as control and filtration to the stream from the structure to keep it a little bit further back would actually complement the bank as well as, filter appropriately to get into the stream. The topography of the land, the existing concrete pad predominantly is obviously sloping mildly. Off of the concrete pad, you start to gradually do about a 3-foot drop within 5 feet. So it's drastically dropping towards the stream area as well if you start to migrate to the west with this carport. And then those are my initial comments.
Okay, thank you. Any questions for Mr. Lassiter?
Mr. Lassiter, do I understand your testimony correctly that you have kind of explored other options as far as constructing the carport within the existing setback requirements, and that basically what you found is that doing so could be, one, create erosion issues, and two, be harmful to the trees that are there?
That is correct. The arborist was, he made me aware of the impact of the root system if I was to push it closer to the bridge, as well as the mild degradation of the stream bank already currently happening.
Thank you.
Any other questions for Mr. Lassiter? Max, is there anybody that wants to speak for or against this case?
No one has signed up to speak for this case.
Okay.
I'm sorry, Mr. Chair. Mr. Lassiter, you said that it would impact if you used one of the other two choices, it would impact how you entered the carport. Explain to me how that works. How would that impact how you entered the carport? Because I see the driveway, so you would just.
Can you go to Exhibit 7, Lisa, please? So you see the top left-hand corner of the blue box is in the middle of the driveway.
Mr. Lassiter, does the carport have to be the 32 by 22, or is that just, I'm just asking the question, or is that just the desired dimensions?
That is desired to cover up the actual west to east coverage of the existing concrete pad.
Okay. All right, I understand now. Any other questions for Mr. Lassiter? Okay. Lisa, any final comments from staff?
No comments from staff.
All right, Mr. Lassiter, I'll give you the final word. Any final comments?
I just appreciate everyone's time and effort into this. It's been a long struggle, but definitely educational, and just trying to make a homeowner happy and then abide by city and council rules. So I appreciate it.
All right, thank you. If there's no other questions for staff or for Mr. Lassiter, I'll go ahead and close the hearing. Let's see. Mr. Welch, we haven't started with you yet. We'll start with you for your comments.
Thank you, Mr. Chairman. Just looking over, I'm leaning towards improvement. I don't, based off of the comments of Mr. Lassiter, as far as if we move it closer, how it will, just mess up with the rooting of the trees, and that stream that's already eroding. I have no problem with approving this variance.
Okay. Mr. Floyd.
Yeah, I'm kind of torn here. Obviously, staff, the information they provided is that you could construct a carport within the existing setbacks, which, when I look at the factors that we're supposed to consider, makes me question whether this would be appropriate for a variance. But I think given the impact on existing trees and the stream, those are things that are peculiar to this lot. And I think, again, I'm not 100%, but I certainly lean towards granting the variance.
Okay. Miss Allen.
I would lean toward approving it.
Okay. Mrs. Dryden.
My only concern is the narrow 3-foot buffer on the one side that you are pretty much eliminating, because they're asking for the side, they're asking, it's a reduction of 1 foot 3 inches, and it's only a 3-foot side yard. Is that the side yard that faces the street, that borders the street? Or is that the side yard that borders the neighboring home?
The neighboring home.
That's my only hesitation. I mean, I understand about the trees and I understand about the erosion and everything, but goodness, it's only 3 feet to start with, and you're basically cutting it in half. So that's my only hesitation.
Okay.
I'm open to other comments or suggestions, but that's my only worry, because if I'm the neighbor on the other side, I'm thinking to myself, we've only got 3 feet, and 3 feet is not very far. And realizing it's a narrow lot already, but then you're building something that is it's just very difficult for me.
Okay. Lisa, is there an exhibit there that shows the picture that we could get a better feel for that distance?
Let me see if it's. You can see on this one driveway how it joins the neighboring.
Is there the picture that actually shows the driveway? Is it my see the screen looking towards the back of the property? That one.
But 9.
Yeah, that one you could see essentially, Mr. Dryden, the carport is going to be over the existing concrete.
Okay.
Mr. Chair.
Yes, Mr. Powers.
Just to clarify, did the board go into discussion and deliberation at this point, or are we still open?
Well, I closed the hearing, so we're in deliberations. Do you need me? Do you think I should reopen it?
No, I just, with Lisa's comments in that regard, I was just thinking we should probably give the applicant an opportunity to weigh in. If Lisa had just provided just a photo for the board, I think that's one thing, but I think her commentary now.
Okay. Yeah, I was just asking for the figure. I wasn't. Yes, Mr. Laster, we'll go ahead and reopen it. Mr. Laster, do you have any comments about the closeness? Or was I correct in my assumption that the carport will be just over the concrete driveway that currently sits there?
Yes, sir. The post and beam, so the post will be cornered up right behind that concrete pad. So it'll be off to the left and right.
All right, thank you. So we'll go ahead and close the hearing. Mr. I don't know if that helps this figure helps you any, Mrs. Dryden.
It does. And now, is this carport is an open structure or a closed structure?
I don't know, but if we do, we'll reopen the hearing so you can ask Mr. Laster that question.
Thank you.
It is an open structure.
I'm sorry, say that again?
It is an open structure.
Okay, thank you.
All right.
Thank you, Mr. Chair.
All right, we'll reclose the hearing then. Sorry, court reporter, for all this back and forth. uh, my initial thoughts were that I was leaning against it, but because there was sufficient area to redo it or to move it around. But looking at the site and with the stream and the trees, my only concern, and this might be a question for Mr. Powers, is that staff has put in the findings of fact. They're concerned that this will be a precedent setting if we allow a structure to be constructed in the back of the property. It's setting a precedent. And I, based upon previous cases and over the years and just previous cases, this is a individual to this property and not for the entire area. Is that a true statement, or is that Mr. Powers?
Yes, sir. Thank you, Mr. Chairs. So I think that if there are factual circumstances that are identical to this case, it could be a precedent for other cases of similar nature. Again, you're not just having it just for the Dilworth Muse area. It would have to be very similar in regards to the factual matter, the request, all of that, to the extent that all of that would then be precedent for another variance request that may come along. If there are
a similar type property, narrow property with a stream and mature trees.
Right. And you have mature trees, you have a bridge, you have the driveway, narrow lot. That all of that has to come into play in regards to that. And access as well. Again, the access looks like it's on a different street than where the actual home is oriented towards. So I think all of that would have to be as part of the actual basis to say that this is precedent. Is there a possibility that this could be used to make a actual analogy that this is why I should get it? By all means, anyone can use any of your previous decisions to say, hey, you've done it this in this other instance. We hope this will sway you to do it again, but it's not exactly binding precedent unless the actual factual component is exactly the same in all instances. We've had multiple cases over the course of my time and as well as Andrea's times where there are factual distinctions between each and every decision, even though they may be similar.
All right. Thank you. That helps me. Okay. Is there any other questions, comments, deliberations that we want to make? Or are we ready to make a motion? And once again, the chair cannot make a motion.
Motion to grant the variance.
Okay.
A second.
So we have a motion by Mr. Floyd and a second by Mr. Welch to grant the variance. We'll take a roll call vote. Mr. Floyd?
Yes.
Mr. Welch?
Yes.
Miss Allen?
Yes.
Mrs. Dryden?
Yes.
Sanderson, yes. Okay, we'll need to modify our findings of fact and conclusions of law to based upon our decision. I think that number 19, I think we probably need to strike based upon my just previous discussion with Mr. Powers. Is that correct, Mr. Powers?
One moment. Yes, 19 would need to be stricken, excuse me.
I think
Also,
13 and 14 should also be stricken.
Number 12 too, right?
Number 12.
We would rewrite that to say the hardship does not result in action taken by the applicant.
Okay.
Correct. 12 would be as offered. 13, I think you can either delete 13 in its entirety, or you could rewrite 13 to address the stream, the mature trees in that regard.
And access.
Yes, sir.
Yeah,
I think we should just delete it.
And also the same thing with 14 as well.
Yeah, I think given our concern about setting a precedent, it would probably be better to actually include the reference to the stream and the mature trees, so we have a record of that.
Yeah, I think 13 should be left that way, and then at the end, however, put a comma, then however, due to the unique nature of this property where there is a stream, mature trees, and access issues in this location of the proposed carport, there is no other compliant area on the property for the structure, or something to that effect. I'll leave it. I'm not a wordsmith, so I'll leave it. I'm an engineer. I'm not a wordsmith, so I'll leave it to Mr. Powers or others that can do that type of wordsmithing.
I will draft something quickly and place this in your chat for you to review in a moment. I would also ask, Mr. Chair, does the board want to consider whether or not they are conditioning this variance on the carport being in existence? Excuse me, it's not carport. It's a carport or garage?
The carport.
Carport.
So just to make sure that if the carport is demolished or removed in its entirety, nothing else could go back in its place. So I didn't know whether or not the board wanted to consider that, given the circumstances, that it does appear that we're okay with allowing the variance, but being that it's a variance, it is allowed for anything up to that point. So I didn't know whether you want to kind of condition this just to solely be for the carport, remove the carport, then extinguishes the variance.
I'd like to say that because I don't want a carport that's open. I don't want it to turn into down the road a closed, so they can build an enclosed carport or a garage, because we've given them this variance.
Or a garage with heated space or anything.
Yes, or a garage with heated space or anything down the road, because these homeowners may not own this house forever, and the next people may decide, oh, well, we want a full garage with heat in it. So I would like to make some stipulation that should this structure be demolished, it can only be replaced by another open carport, if the structure is damaged, but not with any other structure.
And if the board were to go down that path, as I understand from the city's perspective, any repair and maintenance is allowed on the structure.
Correct. Yes.
If it's demolished, they could then turn around and rebuild the carport back on that same area in question. But we could put the restriction, to your point, of it cannot be enclosed or allow for any kind of heated type of space in that regard. But I can draft language to that effect if the full board votes on that and were to approve that condition.
Well, then I make a motion that we ask Mr. Powers to put that wording in, that we are supporting an open structure carport that can be maintained, and the possibility that it could be replaced as originally stated, but cannot be an enclosed space or a heated space.
Second that.
Okay, we have a motion by Mrs. Dryden, a second by Mr. Welch to have Mr. Powers draft the language for the findings of fact and conclusions of law, and to make sure that the structure that we are approving is an open carport and cannot be converted into a closed garage or closed structure with heated space. We'll take a roll call vote. Mrs. Dryden?
Yes.
Mr. Welch?
Welch, yes.
Miss Allen?
Yes.
Mr. Floyd,
Yes.
Sanderson, yes. All right. So Mr. Powers, if you can draft those two findings of fact for us.
You can just give me roughly a minute. I can have both of those up for you.
Thank you. And is there any other changes that we need to make while Mr. Powers is drafting? Obviously, we need to change the conclusions of law.
Right, that's what I was gonna say, that unnecessary hardships would result from the strict application of the ordinance. And the hardship does result from conditions that are peculiar to the property. And I think there, if you wanted to put something about the unique streams or trees or access.
He's doing the red number. He's
Oh,
doing that
okay.
in one of the findings of fact.
Okay.
Yeah, I just got in the findings of fact. I mean, it's like 12 through 20 probably need to either be deleted or rewritten.
Okay, Mr. Powers has just sent out the revised number 13.
Okay.
We would need to add the unique character of the property. So the property after the character of, and before the with several mature trees on it for that. So then we do that, make that slight revision to Thomas's number 13, and then we strike number 14.
Well, 13, well, maybe you said this right. However, due to the unique character of with several mature trees.
Yeah, that's why I said it should
Okay.
be unique character of the property with several mature trees.
Okay, yep.
And the creek running through it, you could say it there because you're referring to the property where you've added it in the middle of the sentence.
Yes. And then we'll strike number 14 and number 15. Number 16, take out the word no, there is evidence. Number 17, the hardship is peculiar to the property, so strike the word not. Number 18, I don't think there's a reason to have 18. 19 obviously is gone. 20, granting the variance will not alter the essential character of the neighborhood. And then just finish it with a period after neighborhood, I would believe.
Yep.
And 21 that's just an information one. And then in the conclusions of law would result from the hardship would result from the strict application. Hardship does result from conditions that are peculiar. Hardship does not result from actions taken by the applicant, and requested variance is consistent with the spirit. Did I miss anything? Thomas, are you still working on the one about the restriction?
Yes, sir. I was trying to find some language that would be ideal for the board. More or less, and I can find some previous language that I've used. It would be that this variance is conditioned on the existence, is conditioned on the construction, maintenance, and/or repair of the proposed carport. Any additional any additions to the carport other than what was proposed to the board shall be subject to review by the zoning staff. That's the general idea, but it just more or less will say whatever they build is what they're bound to going forward. If they modify what they build, then that will subject them to further review by staff or either a future variance and/or any other review.
Okay. Just make sure that it's an open carport.
Yes, sir. I will, because I cannot put that, I don't have that information readily available.
Right.
What I would ask at this time is the authority to draft that language. And what I would do is once I have drafted the language, I will send it out to you all first to let you know what the language will be. And that way, if there's any concerns or thoughts about it, you can let me know, but I'll at least send it out before it is actually placed into the final decision letter.
Yes. Okay.
I make a motion to give Mr. Powers the authority to draft the language that we've discussed and to share it with us before it's put into the finding of facts.
I'll second.
We have a motion by Mrs. Dryden and a second by Mr. Welch to authorize Mr. Powers to develop the finding of fact for the restriction on the carport, and then provide that to the board prior to final letter being included in the final letter for this case. Take a roll call vote. Mrs. Dryden,
Yes.
Mr. Welch,
Welch, yes.
Miss Allen,
Yes.
and Mr. Floyd.
Yes.
Sanderson, yes. All right, so now we just need to have a motion for the approval of the findings of fact and conclusions of law as amended, or as will be amended.
I make a motion to accept the finding of facts and conclusions of law as will be amended.
I'll second.
Okay, we have a motion from Mrs. Dryden, a second by Mr. Welch to approve the findings of fact and conclusions of law as have been amended and will be amended by Mr. Powers as revised and additional comment. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Floyd,
Yes.
Miss Allen,
Yes.
Mr. Welch,
Yes.
Sanderson, yes. All right, so that's Mr. Powers. We'll get that information pulled together and get it out to the board.
Will do.
Thank you, Mr. Lassiter. Our last case is case number 2020-070.
All right, this is a building coverage variance request. The applicant is requesting a 355 square foot variance, the maximum building coverage requirement in a single family zoning district. And I'll give you a minute to look at your findings.
And Max just sent them out.
While we're waiting, Mr. Chair, what happened to case 2020-079? It was on our agenda.
Yes, that case has been removed from today's agenda.
Okay.
Max said that at the beginning of the,
Oh, I'm sorry, I didn't hear that.
yeah, before the, I think he and I talked about it, but they removed it before our meeting started today.
Okay, thank you very much. I apologize.
No worries. Okay, Lisa.
Government Exhibit 1 is a vicinity map of the property. Government Exhibit number 2 is a zoning map of the property. The property is zoned R5 single family, and it's got other R5 single family properties adjoining it. Exhibit 3 is an aerial map of the property. The property is currently vacant. Exhibit 4 is a sub-aerial map of the property. Exhibit 5, background of the property. The property is given a maximum building coverage allowance, which is the same for all detached dwellings in single-family zoning districts. Building coverage is the portion of a lot developed with principal and accessory buildings. So it's basically anything with a roof on it. Sidewalks, patios, and those sorts of things would not be considered building coverage. So it's just anything that's a building. So depending on your lot size in the blue table on the bottom, you have a different maximum building coverage allowance. And so the applicant's lot is 9,147 square feet. So he falls into that between 8,501 and 15,000 square feet. So he's allowed 35% building coverage for the. A building permit was pulled for the property in 2016. And currently, the single-family home that was permitted is under construction on the lot. The home that was permitted, you can see in the top middle, in the right side of the survey, showing the actual amount of building coverage that was proposed for the lot through that permit was 3,198 square feet. And that's compliant with the maximum building coverage allowance for the lot. The maximum building coverage allowance of 35% of the lot is 3,201 square feet. So the applicant is requesting a 355 square foot variance from the 3,201 square foot maximum building coverage allowance to allow 3,556 square feet of building coverage, which is 39% of the lot area. Exhibit number 8 is
Lisa, excuse me, I had a question.
Yes.
You go back to that previous exhibit. Where did you come up with that number? 'Cause I'm looking at these numbers and I don't see a 3556 number.
Okay.
I see a 3437 heated total, 651 for a garage. Just a minute, Mr. Calcara. We need to have staff answer the question first.
Okay. So if you look at the middle chart in the top middle portion, And you see that it says the lot is 0.21 acres.
Yes.
And then there's a 3,201 square foot maximum building coverage.
Yes.
And then under that, the actual of 3,198 square feet.
Yes. That's a 3-foot difference.
Correct. So they're compliant now.
Right.
So what they want to do is add an additional amount of building coverage and get 355 above what's allowed, which is the 3,201 square feet to give them 3,556.
Okay, so that's not in this chart. That was just, you're just showing this chart, we're just showing the maximum allowed and the actual permitted one.
The chart was just to show that what was permitted, the home that was permitted for the property is compliant with the maximum building coverage allowance.
Okay,
But
I understand.
The variance request would exceed that.
All right, thank you. I understand now.
Okay. Exhibit number 8 is the consideration that the home permitted for the lot can continue without the need for a variance. And here's some elevations, the right elevation and the rear elevation. And I believe that what they would be covering is that deck area that you can see on the right side of the right elevation into the rear of the home. Exhibit number 9, considerations, is that no other homes in the area appear to exceed their maximum building coverage allowance. And then exhibit number 10 is a photo of the property showing that they've laid the foundation, they're working towards their permitted structure. And that's my presentation if you have any questions.
All right, thank you, Lisa. Are there any questions for staff?
All right, Lisa, where is it that they want to add the additional building coverage for that porch?
They want to cover a deck, and I believe that the deck is the one shown on exhibit 8 on the right elevation on the right side, that deck area.
Right.
And then on the rear of the.
That's the difference in the 300 and some feet that they're looking for?
Yes.
Any other questions for staff before we let the applicant do their presentation? All right, Mr. Calcara, before you start, I hope I said your last name correctly. You swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand. And you're on mute.
I do. Sorry.
All right, thank you. Thank you. And then before you start, please state your name and address for the court reporter.
Sure. Michael Calcara at 1000 Lee Avenue in Charlotte, North Carolina.
Thank you. Go ahead and make any comments or presentation that you would like to.
Okay. Yeah, no, absolutely. And thank you, Lisa. I think you really hit the nail on the head on summarizing most of this this consideration here. And thanks to everyone for your time. So one other piece. Now, I believe, I don't recall the exact exhibit that was shown that detailed the specific percentage requirements per lot size, right? And there's, it's clear to me, right, what the particular pieces. Maybe this is actually perfect. I'd like to kind of read this to you all and maybe we can follow along together. So currently building restrictions define my buildable area at 35% or 3,201 square feet. Due to the lot size of 9,147, which makes total sense, right? 35% there. What's kind of funky about the math when you think about it, though, is of note, lot sizes 8,500 square feet and below are permitted at 40%, or give you a maximum buildable area of 3,400 square feet. You know, I understand the spirit of the law here, right? We don't want to have massive structures taking up the majority of a lot, right? So that makes sense. What I think is sort of, and I don't want to say missing because that's maybe stepping over, but something to consider, right, is sort of this graduated tier that I kind of outlined here that kind of makes more sense to me, right? Where you look at the first 8,500 square feet of your lot and say that should be permitted at 40%. And then you step through at 35% for that square footage above 8,500, right? And that's kind of what I outlined there. Using that logic, you would get to 3,626 square feet being permitted, right? Simply because of the kind of ironic situation where if my lot was only 8,500 square feet, I would have been permitted 3,400 square feet. My lot is actually bigger than that, but I'm only permitted about 3,200 square feet. So it's kind of this funny math where I understand it, it just is an opportunity maybe for a graduated sort of similar to a tax setup, right? Where you would graduate up the tiers, right? And tax that particular piece. Similar sort of idea here, so that, my particular situation has me slotted at the lower end of that 8,500 and above situation. So, in summary, my plan right now is, as Lisa articulated properly, right, is in compliance, and it's at 3,198 square feet. That additional 355 square feet would be to complete the porch. That total would be 3,553 square feet. Again, if you follow the logic outlined above, it would be less than that, if that sort of makes sense. So I would definitely ask everyone to sort of think through that. If there's questions, I can certainly kind of detail my thoughts around how I got to that number. In addition, right, I think it really fits with the character of the neighborhood. Screened-in porches in the area. Nothing. It's nothing egregious, or it's not being used in particular. I know there's some concerns in that area around Airbnbs. The square footage is not being used for that, right? It would just be simply to sort of further cover the porch and provide some shade, frankly. We talked about there was the aerial view of some of the other lots in the area. They're all about 15 feet wider or so. So it's, while 70 feet wide is not necessarily a narrow lot, but it's a bit narrower than most of the other neighboring lots as well. So yeah, I think those are some of the primary considerations there that I think are worth noting, in addition to everything that Lisa kind of outlined. Does that help?
Yes, thank you, Mr. Calcara. Any questions for the applicant? Lisa or Shad? Maybe this may be a Shad question, I don't know. His breakdown of is there an explanation as to why the smaller side, the 8,500 square foot, the smaller properties they can use more of their property just because they trying to get equal structures, is that correct?
Correct. It was how it was adopted by the city council that the smaller the lot, the more building.
Right.
The greater, sorry, just want to clarify, the greater buildable percentage, right? Because in this case, right, the buildable percentage is higher, but my buildable area actually becomes smaller. Does that nuance make sense?
Well, it becomes smaller because you're right there on the border.
Right. It's sort of you would assume that would be figured out, but
you were up to the 10,000, 15,000.
Yeah, if I had 15,000, we'd be totally different situation.
So, I understand your point. You're right there near the border of it. So it's one of those fluke.
Right. And the spirit makes sense, right? The intent makes perfect sense, right? You don't want these massive, taking up that much space. But it is, like you said, I think that's the peculiar piece of this, right? Is that I'm kind of at the lower tier of that.
All right. And any other questions from the board, for staff, or the applicant? Okay, hearing none. Lisa, is there any final comments from city staff?
I think that we had someone that signed up to speak.
Is there someone that signed up, Max?
Yes, we have a neighbor signed up to speak, Toby Holmes.
Okay, I'm sorry, I didn't realize that. So, all right, Mr. Holmes, before you start, you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand.
Yes, sir, I do.
Okay, and then please state your name and address for the court reporter before you make your comments.
Sure. Pars Thomas Holmes III at 3010 North Meyer Street.
Okay, go ahead and make your comments then, please.
First, thank you all for your time today. I mean, we're 3 hours in. I imagine that you would like to get on with it and also have done this regularly. So thanks for your dedication and your volunteerism to this board. For some context with regard to North Meyer Street over in NODA, I think it's helpful to have this. This is a historic or nationally recognized historic portion of the North Davidson NODA neighborhood that is still comprised of mostly mill homes that have been adapted over the years. I believe the largest one within relatively close proximity to the subject property is about 2,000 square feet, and that's my other neighbor. Other properties immediately across the street and next door to the applicant are somewhere between, I believe, 1,176 square feet. And my lot is or my home is the largest, which is 1,950 square feet. So that's the kind of range of homes we're speaking about. So that's the character of the neighborhood. That's the existing mill homes ranging from approximately 1,200 to 2,000 square feet. What is being proposed is outside of the character of those homes, in my opinion. The ground floor of the applicant's home alone exceeds his neighbor's home by 65 square feet. I'm sorry, 65% larger in coverage. His home is 40% larger in coverage than my own home. And don't get me wrong, I do applaud Michael for his investment in our neighborhood and building to the maximum capacity of his own lot. He is well within the confines of the law to do that, and I'm excited that he has made that investment in our neighborhood. However, the fact that his lot is 7.6% less, or I'm sorry, above a threshold of 8,500 square feet, so he could build something that would ultimately be smaller than the footprint that he is proposing right now, is not logic that I can necessarily follow. The letter of the law was stated in advance of his purchase. There were other lots commercially available to him to accommodate the size of his home. There were other home designs available to him that were slightly smaller in footprint. So I have trouble connecting a hardship to this request. One thing on the application I'd like to point out is the request is not 1% of the total lot size. It's actually 3.9% of the total lot size. And it's actually 6.8% larger than the existing footprint of the home today. So by approving this variance, it would increase the home size by 6.8% and allow for this additional square footage. Very candidly, the fact that it is this roof line is located in the rear of the home may create some illusion that it's out of sight and out of mind. But in reality, if you think about it, basically this exceeding the maximum coverage requirements, it doesn't necessarily go behind. It goes to any point in the home. So it's not necessarily this hidden piece of the home. The home takes up the full allowable space at any part of the lot. So I think that is an important thing to consider, that it's not necessarily a hidden roof line by any means. So in terms of the hardship, again, I don't understand where the hardship is exactly. The request in the home itself is not necessarily within the character of the neighborhood. However, it is by all means well within the legal rights for Mr. Calcara to build in. But I do not, as a neighbor, see the reason to exceed that amount, given that this property and the lot does not really have any encumbrances whatsoever. There were some things cited in the application, but all things considered, the lot is of a normal size. It's a 9,000 square foot lot, which is just short of a quarter of an acre. It's not encumbered in shape. The topography does fall off to the south, but not in a way that makes it impractical to build in any way. I think what we have here with regard to the request is simply the desire to put I think the home that he really wanted on a lot that's just the 7.6% too small for it. And I think we can speak in relative terms with regard to how much is close to the 8,500 size, but I don't think the my personal opinion is 7.6% is not necessarily close. It's obviously much larger than that normal lot size, and in my opinion, there's no reason to grant a variance in these grounds, particularly given the fact that, as you discussed in a previous case, it sets a precedent for similarly shaped and sized lots in the area, which pretty much includes all of them. So that is those are my comments for the afternoon. I welcome your questions.
Thank you. Are there any questions?
I'm sorry, am I allowed to respond back, or should I?
Yeah, you can. Yeah, you can respond back.
No, I appreciate that, and thanks for those comments as well, Toby. Obviously coming into the neighborhood, I've been a resident of Charlotte for over 11 years now. I was in the Plaza Midwood area, uptown prior to that. Went to school at Wake Forest, so certainly Charlotte is near and dear. Brought my family down here, so certainly recognize and Meyer Street in and of itself is a fantastic street. So certainly want to be neighborly in that regard. So I just want to bring to the attention a couple points. One, particularly around the lot size itself. When I was looking at Polaris and 3G, the neighboring lots are 0.312, and I outlined this in the documentation, 0.312, 0.243, and 0.256 in the neighboring areas right around me, compared to my 0.21. So they are in fact a good bit bigger. So do want to kind of talk through that a little bit. As far as the direction the street is going, just 2 months ago there was a home over 3,200 square feet completed, newly constructed. I believe it's 2907. 2907, I believe, North Meyer Street, about 4 houses down or so. So that's certainly, if we want to talk about the direction the street is headed, right? I was just talking to another neighbor who was kind of saying, I was apologizing for the commotion of construction, and they said, well, we understand this is, what's happening, and there's another house that, was just built down the street. And then I believe there's another one, a couple on the corner of Myers and 34th there. That's rather large. So I understand that there is a feel to the neighborhood, right? But given my history in the area, and I understand that, right? So certainly I'm not looking to build anything that's while the size may be greater, I don't think it's out of character from that development. I'm not doing anything particularly uncharacteristic, if you will, for that. So that would be another point as well. In addition, they said there was mention of the previous home that was there. There was no previous home there. It was an empty lot. So if that was decades ago, perhaps I'm unaware of that. But to the better part of my knowledge, there hasn't been anything there for quite a long time. As was also articulated by folks in the neighborhood, that they kind of just were wondering, when that lot was going to get built on, just given the fact that we all know that the NODA area is hard to find homes in, and this was an empty lot, so it was quite unique in that situation. There were some considerations around, while not a deal breaker, there was a fire hydrant in the front of the home that sort of had us shifting some things around. So that kind of redesigned some things. And I think that at the end of the day, right, this is an attached screened-in porch that's extending a bit out the back. I mean, we're not looking to put a massive anything really. It's just kind of an extension of the roof in the back. And I do think that if we pay particular I don't want to say attention, but we do revisit that table, we would see that it just from a spirit of the variance perspective, the law perspective, over 8,500, I am in this funny tier, right, where it feels, and I'm only asking for what's fair, right? Like, if I have a bigger lot, I should be able to get more square footage than the smaller lot, right? I mean, and that's kind of what I would kind of end my kind of perspective on, is that if my lot was 8,500 square feet, I could build 3,400. Right now, I can build 30. So it just doesn't really feel right to me from that perspective. Obviously, from the letter of the law here, that's how it's articulated. So that's why I'm here for the variance. If that makes sense.
Thank you.
I have a question. Mr. Carrera, when did you decide that you wanted to cover this porch? Was it in your original design plans when you pulled the permits?
Yes, ma'am. So it was interesting. So I had hired a architect and a builder in the area, and we submitted our first proposed plan. That was rejected, I think, around July 2nd or so, citing exactly this ordinance. So there was no intent to sort of mislead anyone. It was just I guess just the builder was unaware of it. And so when we walked through it, we said, okay, so we redesigned the plans to be in compliance, is what you see today with the 3,198 or so. So that just to keep under that permissible amount. So we redesigned things for that. And then, what we're requesting is just then to just put the roof over that deck.
Thank you.
Mm-hmm.
Are there any other questions for the applicant or for staff for Mr. Holmes? All right, then Lisa, still any other final comments before we close the hearing?
There's no other final comment.
All right, Mr. Kakara, you have the last word. Any final comments?
No, I would just emphasize everything that Toby's been saying as well, right? I mean, and I'd like the committee to take into account that I have been part of Charlotte and for a long time, right? And I live and work here. My family's here. I understand. And Myers Street, from what I've met a number of folks, everyone's very nice there. Ray across the street. Like I understand what I'm moving into from a character perspective, from a look and feel. So, Toby, I know you and I haven't had a chance to connect prior to this, and maybe this isn't the appropriate forum, but I do, would like to just articulate that that intent is certainly in front of mind for me, and making sure that everything kind of fits in with the look and feel. I certainly don't want to be, that neighbor. So.
All right, thank you. There are no other comments. We'll go ahead and close the hearing and begin our deliberations. Let's see. Ms. Allen, we'll start with you this time. What are your initial thoughts?
I lean toward approving the variance.
What?
Okay. Mr. Welch.
Couldn't find the music, but I'm kind of torn because I'm trying to understand the hardship of not approving this variance. I'm just not seeing where there'll be a hardship. Again, understand that you're just asking for the small portion of the roof to cover the deck, but what hardship would occur if we do not approve this variance? I'm open to hearing from the other colleagues.
Okay, Mr. Dryden.
I agree with Mr. Welch. I don't see where the hardship is. I mean, I understand it was on his original plans, but it didn't fit the code. And I understand that, it's right at the cusp of too big, too small. But there's a lot of issues we take up that are too big and too small. And if we start saying, well, we'll fudge a little bit here and fudge a little bit there, then how do we honestly say to people, this is the rule, this is what you have to follow? I understand he would like to have a screened-in porch, but the lot size and the area does not call for it. And I'm looking for his reasons where he said it was a hardship. I'm trying to find that. And he talks about the fire hydrant and the topography, but that has nothing to do with covering the screened-in porch. So I'm leaning toward not approving the variance.
Mr. Floyd.
I'm also not inclined to grant this. I certainly understand the applicant's point with regard to the lot size and what percentage you get, but I really think that's an issue for city council or, it's not our job to rewrite the terms of the ordinance. I do have a hard time, as I apply the 4 factors that we as a board are supposed to apply and to decide whether or not to grant a variance. I mean, we just don't have complete discretion. You have to identify a hardship, and then we have to determine that that hardship doesn't result from the actions taken by the property owner. And here, to me, this is a new build. The property owner has control over the design of the home. And, you build a house, you make decisions, and you can decide, I want to use my square footage for a screen porch, or I want to have greater interior square footage. Those are decisions that the owner is making. And so, I don't see how you can find that the hardship doesn't result from the decision of the owner. So, again, applying the factors that we have to apply. I certainly understand the applicant, the situation they're in. I understand the desire to have a screen porch, but I don't have this complete discretion to do what, I might feel bad for somebody. I have to apply these factors, and applying these factors, I think, weigh in favor of declining the request.
I agree with my colleagues. I understand what he wants and what the desires are. But as you said, looking at the hardships, the 4 that we need 4 criteria, we have to go and justify unless there are extenuating circumstances. I'm having a difficult time being able to say that the hardships are not self-created in this case. So, all right. Is there any other deliberations or questions from the board to each other?
Mr. Chair, this is Emma. Having heard my colleagues, I'm going to reverse my vote.
Okay. We haven't got to a vote yet, but okay.
Yes.
Then is there a motion? I guess, let's see. Staff is recommending a denial of the variance. So Thomas, this is from a protocol standpoint, do we need to make a motion to approve? Is that a motion to deny since staff denied it? Is recommending denial, or is a motion, do we need to recommend? What's a motion to approve get us in this case, since staff is recommending a denial?
So the board is recommending approval, then you just take a motion to approve irrespective of the recommendation from staff. Whatever vote you take, it should be either a motion to approve or a motion to deny, irrespective of staff's recommendation.
Okay, so if we want to approve the variance, we say approve, make a motion to approve the variance. If we want to deny the variance, we just make a motion to deny the variance.
Correct.
Okay, like you said, irrespective of staff's comment in the findings of fact.
That is correct.
Okay, I just want to make it clear so that we didn't have a misunderstanding in the motion. All right, with that information, is there a motion one way or the other?
I'll make a motion to deny the variance as requested.
Okay.
This is Emma, second.
We have a motion by Mr. Welch and a second by Ms. Allen to deny the variance. We'll take a roll call vote. Mr. Welch?
No. Oh, yes.
Yes to deny.
I'm sorry.
Okay.
Yes on deny.
Okay. Ms. Allen?
Yes. Yes to deny.
Okay. Mrs. Dryden?
Yes to deny.
Mr. Floyd?
Yes.
Sanderson, yes, it is denied. Let's look at the findings of fact and conclusions of law. Do we need to keep in number 14? That's more I think that's more of an opinion versus a fact.
I would be comfortable with the deletion of number 14.
Okay. I think that was the only one I saw the change with.
I didn't see anything else. Motion to approve the finding of fact and conclusions of law.
As amended by striking 14.
Yes.
Okay.
This is Dryden. I'll second that.
Okay, we have a motion by Mr. Floyd, a second by Mrs. Dryden to approve the findings of fact and conclusions of law as amended by striking number 14. We'll take a roll call vote. Mr. Floyd,
Yes.
Mrs. Dryden,
Yes.
Miss Allen,
Yes.
Mr. Welch,
Yes.
Sanderson, yes. All right. We have a couple other things. Max, you have adoption of the findings of fact from case 2020-032. Is that from the last meeting?
Yes, that is from the last meeting. Those are the two cases that went the opposite direction of what staff had recommended. And those were sent to you along with the applications.
Can you refresh my memory? What is the 03? Which case is the 032?
032 is the Talibi Pool House, and 057 is the Pebblebrook addition.
All right, let's do the let's see. I can't remember who sat in on those on 057.
I can tell you.
Yeah, I was not here at the last meeting.
Right. Does that make a difference, Thomas?
So without being fully briefed on procedure here, I'll probably have a few questions I would need to ask of Max and Lisa as to the vote that's being taken by the board.
Do we just want to table these until we get up till, since we have, just for everybody on the board's information, Andrea is no longer with the city. She left and is now taking a position with the city of Shelby, correct?
That's correct.
So Thomas today is sitting in as the board's attorney, and he was the board's attorney for many years before Andrea came on board, and he will be with us until city attorney, I guess, they reorganize and reassign Andrea's board assignments to whoever on staff gets them. Which that may be next month, that may be the month after, I don't know. So with that in mind, do we want to, I know that on 032, the other case, there was correspondence back and forth to Andrea and to Ree about that case. And I don't know, Tree, we haven't heard from you today, but I don't know what your thoughts are on, I never heard anything back between conversations that you and Andrea were having. And with Thomas being here, would it be beneficial for us to just table the adoption of those findings of fact on these two cases until?
Mr. Sanderson, Mr. Chair, now that I've actually scanned through my emails, I know there was some recommendations for you to amend your previous decision on 032.
Let's amend the letter.
Right. A third party had made a request to the board to amend your previous decision. Is that the item in question that you're talking about?
On 032, yes, on that case, yes.
Okay. So I didn't realize this was going to pop up or that this had already reached your desk. But I have had conversations with the extra third party, and my recommendation to you all is to let the decision stand and not to undertake any revisions at all of 032.
Okay.
Your decision was previously made. If we were to go through the process of actually trying to reopen the actual hearing, there are a multitude of legal issues that I think could be problematic in that regard. So as such, we'll leave the decision as it is currently written. And if there is an appeal, I will defend that with assistance from Tari in court.
I just want to clarify that the two items, the adoption of the finding of facts for 032 and 057 are simply just the board directed staff to reword some of the findings following the denial in the case of 032 and the approval in the case of 057, because the staff findings did not match the outcome.
Yeah, Andrea was working on language. She was making some revisions to the findings of fact.
So it doesn't have anything to do with the third party reaching out to staff regarding findings of 032. It's just simply that the board directed staff to revise the findings.
Yeah, I mean, I thought we had approved the adoption. We had adopted the findings of fact and conclusions of law as amended, and as we directed Andrea to make the wording changes to a couple of the items. But I mean, we had adopted them last month, so I don't see a reason to have to readopt them. Is that correct, Thomas?
If you directed Andrea to make edits, ideally it would have been the same type of delegation that has been done today, where there was particular requests that were made and the board approved those, that delegation. I would think that based on the decision, if a decision has already been sent over to you, Rick, to sign, and to Shad to sign, then those edits would have been already taken care of. If the board is asking to redo a previously signed decision, then my opinion still would be let this decision stand in that regard.
No, the way those letters came out and were reviewed by Andrea, Shad, and Tari, and then they came to me once everybody was fine with them, the wording, the final letter, and they were signed and sent out, as far as I know. That's why I don't know why we need to revisit those two.
If you want to weigh in, because I'm, from at least my perspective, I saw that it was signed, so I just want to make sure I'm on the same page.
Yes, I'm not sure I'm not sure of the issue here. Typically, the attorney for the board will have some discretion on wording after the board has made its decision with respect to findings of fact, especially if they're not significant changes that change the substance of the letter. So this is a little different. I'm not sure if the changes Andrea made were so significant that you need to reapprove.
No, they were just wording, and I actually sent them to me, and I said, no, this is what we had talked about. And she said, oh, that's right. And then she made another wording change to get it back to what we had talked about. And then I signed the letter.
Yeah, so Max, that we typically don't have to reapprove those. So are we understanding correctly, Max, what's going on?
I believe so. I thought this was just the precedent that was set because we've been doing the past prior to me taking the position. So I was just continuing that on, but I can move forward as we are today in the future.
Has everyone had a chance to review the minutes that Mac is seeking? Okay, Max, have those minutes and letters already been approved by the board?
The decision letters have been signed.
But we haven't approved the minutes. We need to still approve the minutes from last month's meeting, but the decision letters were reviewed and approved and signed and sent out. I believe they were sent out.
Yes.
So those are gone. So I don't see a reason to do anything with those.
No, I agree.
So the only thing we have left to do is the approval of the August minutes, which were sent out. And I didn't have a problem with them, so I don't. If there's a motion from the board to approve the August meeting minutes, we can go ahead and get that done.
Max, when did you send the minutes? Maybe I just didn't pay attention to one. Is it in one of your recent emails?
No, I sent them with the agenda draft and quotations. I can resend to the board if needed.
We can do it. Why don't you do that and we'll go ahead and approve those at our next meeting. There's no reason to hold up everybody today. We can approve the September and August meeting minutes at the October meeting.
I appreciate that because I have to find mine. You know, he sends me a packet and I printed off a lot of things. I just don't see the minutes. I'll have to go back and look at his emails because I'm sure it's there somewhere.
That'd be acceptable, Thomas, to approve both meeting minutes at the next meeting.
That is fine. You may approve your minutes at the next meeting.
Okay, thank you.
And it does not have to be, at least for purposes of minutes, does not have to be the same members of the board in that regard.
Right. Okay. There's nothing else. I will adjourn the meeting then.
Actually, Mr. Chair, if you can just give me 1 quick second, I can send out the condition for the carport language right now for everybody to look at.
Okay.
Thank you. I appreciate that. Just give me one moment.
Everything on 32 is it's done, right? No changes were made or accepted based upon, I can't remember his name, but.
No. We did, Andrea spoke with him, the gentleman, and we brought Thomas into the conversation and made the decision that we would not reopen the matter to amend the decision letter.
Yeah, I kind of thought it was a little odd having an outside party partaking or throwing in his own 2 cents into findings of fact and conclusions of law. It was unusual, but as I believe his concern was just as an interested party, because there's an understanding that this matter will probably be appealed.
I will, Mr. Chair, I will turn the board to the new language that I placed in the chat for the condition for the carport. I just want to put in there again that this variance is conditioned on the proposed use of a carport, and the variance shall expire if the accessory structure is enclosed or any part of the accessory structure becomes heated space.
Sounds good to me.
I think I'm fine with that, except that we need to say something about the fact that they can repair and maintain it.
We can add that language. It's implied, but we can add that language if you believe it's necessary.
If you think it's implied, your counsel, I'm fine going along with your recommendation.
And I will let Teree weigh in on this. Do you believe it's necessary for us to include any language about repairing or maintaining the structure, the proposed carport? I don't think it's necessary to add that, but I just want to make sure from your perspective that if there were to be a post that needed to be repaired, it wouldn't violate at least staff's perspective on the variance.
I don't know if Shad unmuted, but I believe that what you've suggested is satisfactory.
Okay, so no need to have any language about repair or maintenance. No explicit language, excuse me.
Was that something that the board discussed in their deliberations?
They were comfortable with a repair and maintenance of the existing carport. Again, they were fine with the carport being even demolished and replaced. They just didn't want to be enclosed.
Okay, I'm satisfied with that.
Yeah, we didn't want it to be demolished,
not including it,
enclosed and turned into a heated structure.
Shad, do you have any thoughts on this, just to make sure we're all on the same page?
Just conditional on the proposed use of the carport and the variance shall.
No, I'm fine
The accessory structure.
with what your suggestion is.
Part of the accessory structure becomes heated space.
Hearing from staff, and they seem to be on the same page with me in that regard, that the repair or maintenance language is not necessary because once the structure is up, the city will allow them to repair or maintain the structure without a violation of the variance. But I think this language here gets to your concerns, which is if they try to enclose it and make it a garage, or they try to add a second floor above that and make it heated space, that then is more than what you ever intended for that location.
That's correct.
If you're comfortable with that and I wouldn't hear any objections, I'll send this by email over to Max to make sure he can add that as a condition to the previous finding of fact, which if I recall correctly was case number 2020-066.
Yes.
Hearing no objections, I'll go ahead and send this over to him. Mr. Chair, I have nothing further. You may proceed how you deem appropriate.
All right. Thank you, Thomas, and thank you for helping us today. And please let us know if it's going to be you or whoever is going to be our attorney moving forward. Prefer not to be a round robin rotating position. The board, I like consistency, so I liked it when you were there for a while and then Andrea there for a while, so prefer it to be that way.
We will make sure we have someone here ready to go whenever they get here. But like I said, I will continue to serve you to the utmost of my ability.
Do you think you'd be an attorney from current staff or a new staff?
I will probably lean towards new staff.
Will there be some transition?
Yes, sir. I wouldn't put anyone into this position or any of the other administrative boards we have across the city without some training and kind of observation. So I suspect that I'll be probably around, being that this is September going to October, probably for the rest of this remaining calendar year to ensure that whoever's brought on board understands the unique circumstances of being counsel to all of the city's administrative boards and to ensure that we're providing exceptional service from the city attorney's office perspective to you and all of our boards.
All right. Sounds good. Thank you, Thomas. Thank you, Tariq. Thank you, everybody. I'll adjourn the meeting.
All right.
Have a good day. Stay safe.
All right, thank you.